Hi guys, what's up? I hope you guys are doing good. So today we're gonna start with our one more chapter. We are starting with Securities Exchange and Board of India, that is SEBI. SEBI. So please open your notes. We will start with SEBI right now. I hope you have completed the other part of the chapters. I hope you have answered the MCQs also. I hope you have understood the content and I hope you have liked the lecture. If you have liked the lecture, do recommend to your friends. Okay. Now, when we talk about India, in India for shares, the apex body is SEBI. So SEBI was formed, if you have heard a case about Harshad Mehta, if there's a Bollywood series Scam 1992 or Big Bull, a lot of movies are made on him. If you have seen those movies, so you will understand why SEBI was formed. Okay, SEBI is a body which regulates the securities market in India. If you are a company, you want to issue shares to public, public will buy the shares. Now public is interested not only in buying, public is interested in selling also. So that buying and selling ka concept is handled by SEBI. Okay, so the shares are listed on stock exchange. In India, how many stock exchange are there? In India, how many stock exchange are there? Sir, in India there are two stock exchange, that is BSE and NSE. Okay, Bombay Stock Exchange and National Stock Exchange. So those BSE and NSE are governed by a body called as SEBI. So right now first we're gonna study about the SEBI Act, why SEBI was formed, how it was formed, how many people are handling SEBI. Then we're gonna study the rules, the regulations of the SEBI. So there are some regulations like insider trading ka regulation is there, ICDR ka regulation is there, LODR ka regulations is there. All those regulations we're gonna study. So more importantly, it's an MCQ based chapter. A lot of MCQs will be here. Let's underline one by one. Okay. First, SEBI. So SEBI has been established as a body corporate perpetual succession, a common seal with powers to acquire, hold, dispose of property both movable and immovable, to contract as to sue or be sued by in the name of SEBI. The head office of the SEBI is basically at Mumbai. So they say SEBI or they say board. Board also means that SEBI only basically. Okay. So it's basically like a company. These are the features of company. Just basic things we have to understand first. Whatever is the exam content, I will let you know. Number two. Then the chairman and 5 other members. Please underline that the chairman and 5 other members shall be the persons of ability, integrity, standing who have the capacity dealing with problems related to securities market and or have knowledge of law, finance, economics, admin, accountancy or any other discipline which in the opinion of CG shall be useful to the board. So how many people will sit in the SEBI? So there are 6 people. How many members are there? 6. 1 chairman and 5 other members. 1 chairman and 5 other members. The terms of office and other conditions of service of chairman members of the board as appointed shall be such as may be prescribed. So till now 5 people will be sitting, 1 chairman and 6 people will be sitting, 1 chairman and 5 other members. Then right to termination. Now who appointed? So CG appointed. So the CG will have a power to terminate. The CG have a right to terminate the service of the chairman and other members to the board other than its own officials or of the Reserve Bank on the board at any time before the expiry of tenure or by giving notice of not less than 3 months in writing or 3 months salary and allowance in lieu thereof. So how can you terminate? So CG can terminate before the expiry of term by giving how many months ka notice? 3 months ka notice. You can't say like this, okay, CG can't say like this to the members of SEBI, from tomorrow you are not coming. No, you have to give a gap of 3 months. You have to give a gap of 3 months. So, okay, after 3 months you will not come. So, I am terminating you. So, you are not removed immediately, you are removed after 3 months. Okay, but you don't want to see his face for 3 months. You don't want to see his face for 3 months. So, what will you do? You will say, okay, do one thing. Don't come from tomorrow. Take 3 months ka salary in advance and then go. So, that is 3 months ka salary in allowance in lieu thereof. Okay, and allowance in lieu thereof. In lieu means instead of. The chairman and the other members shall have a right to relinquish office. That means they can also give up their office as basically resignation at any time before the expiry of the tenure by giving a notice of at least 3 months in writing. Now it's vice versa situation. Chairman says I don't want to work. Member says I don't want to work. They can also give notice of minimum 3 months. Minimum 3 months. So your 3 month notice has to be given. The CG removes or the voluntary he wants to go. Okay, or 3 months ka salary. Term. How many years they are appointed? The chairman and the whole time member shall be hold office for a bit of 5 years. Circle 5 years. Subject to the max limit of 65 years and can be reappointed by CG. So it is 5 years or 65 years of age, whichever is earlier. 5 years or 65 years of age, whichever is earlier. You can be reappointed but subject to the age of 65. Imagine at the age of 57 you came, 57. So you will work for 5 years, 58, 50, no, 57 plus 5, 62. Okay, then you can be reappointed, but not for 5. You will be reappointed for 3 years because the max age would be 65. Removal. The CG shall have a power to remove the member of the chairman appointed to the board if he has been adjudged as insolvent, or if he is of unsound mind, or if you have convicted of an offence which in the opinion of CG is of moral turpitude like rape, murder, dacoities, or in the opinion of CG it is detrimental. So he abuse his position as to render his continuance in office detrimental to the public interest. So if members you have done wrong, chairman you have done wrong, you can be removed. When you are removing, he will be given a reasonable opportunity of being heard. He will be given a reasonable opportunity of being heard. When he is removed, he will be given a reasonable opportunity of being heard. Okay. Now meeting. The board shall meet at such time and such places and observe such rules as may be prescribed. In the absence of chairman, if for any reason the chairman is unable to attend the meeting, then who will attend? Any member chosen by the member shall preside over the meeting. So any member chosen by the members shall preside over the meeting. He will be the chairman for that particular meeting because the original chairman could not come. Decision. Whenever decision has to be taken, it has to be majority. Majority wins. But sir, what if it is a tie? The chairman will have a casting vote, that means double vote. Chairman or the presiding member will have a second or a casting vote in the event of equality of votes. Then, member not to participate in meeting of certain cases. Now you are sitting in SEBI. You are also a director of Reliance. Let us assume, okay, you are director of Reliance. Now you are director of Reliance and you are sitting in SEBI, and Reliance ka case came in SEBI and you are supposed to vote. You have interest in Reliance because you are the director, you can't vote. So you will not be called as absent, you will be called as what? Abstained. You will be called as what? Abstained member. Because you have an interest. Read I wala point. Understood? No. Vacancies. There are 6 people. Imagine one person gone. So it says chairman should be there and 5 other members should be there. One person have gone. Okay, 5 people are left only. Now they gave a decision against Reliance Industries. Mukesh Ambani comes and says to SEBI, AB sir have taught us there has to be 6 people sitting in SEBI, but you are only 5. So whatever decision you have given, it is invalid. Guys, you tell me, will it be invalid? No sir, it will not be invalid, it will be valid. Any vacancy in the board shall not invalidate any of the acts or proceeding of the board. Similarly, the following reason shall not invalidate any act or proceeding of the board, that is any defect in the constitution of the board, or any appointment of any person on the board, or any irregularity in the procedure of the board not affecting the merits of the case. So it will not invalidate, the decision will be valid. Then powers and functions of SEBI, write their RTP, not to be studied for the exam. See, it will be very rare in the exam. See, SEBI have lot of work. SEBI will be doing all the work related to securities market. So only once and for when you are reading it, you will read just once. Okay, not an exam question, no concept here. So this you will read, this is A powers. Then powers with respect to inspection of books and documents, powers of an order by board. Then come to your, can you see this penalty? Put a tick mark here. Do one thing, read these powers, this page, this full page, until inspection of books of accounts. Till B, read till B, then I'll tell you what to do. Read from the first page, second page, powers of SEBI and A and B power. Read. 5 to 7 minutes, read. Done? Now, passing of an order by the board. Now see, the board basically means SEBI only. Whenever you read the word board, it is basically SEBI. It says the SEBI may, for a reason to be recorded in writing, in the interest of investor, may conduct inquiry, investigation, inspection. Okay, may take any of the following measures, either pending investigation or inquiry on completion of such investigation. What they can do? They can suspend the trading of any security in a recognized exchange. There are a lot of stock exchanges in India, but recognized only two, BSE and NSE. Okay, so they can suspend the trading of any security. That means Reliance security or HUL, TCS, any company ka securities they can suspend. Restrain the person from accessing the securities market and prohibit any person associated with the security market to buy deal in securities like Nirav Modi, Vijay Mallya, then Blue Smart. I think in Bangalore there's a EV wala cab, blue smart, those people have been prohibited. Okay, restrain the person and stopping a persons. Then suspend any office bearer of any stock exchange or self-regulatory organization from holding such position. Any officer of stock exchange he can remove, SEBI can remove. Impound and retain the proceeds of securities in respect of any transaction which is under investigation. Okay, you have bought and sell securities and you have made an unauthorized gain. Okay, illegal gain if you have made, SEBI can confiscate it. Then this is important, attach for a period not exceeding 90 days. Attach, so they will attach bank accounts for maximum 90 days or any property of any intermediary or person associated with the securities market in any manner involved in the violation of the provision of this act. So if you have been caught under this act, so your bank account, your property can be attached for maximum 90 days, provided the board shall within 90 days of the said attachment obtain confirmation of the said attachment from the special court established under so and so section. Such attachment shall continue during the pendency of the proceeding and on the conclusion of said proceedings under section 28A shall apply. Then provide further that only the property, the bank account or accounts on or any transaction entered therein, so it relates to the proceeds actually involved in violation, shall be attached. Shall be allowed to be attached. Shall be allowed to be attached. Now what does this mean? There's a question on this. It says, imagine we take Nirav Modi ka example. So Nirav Modi has HDFC में बैंक अकाउंट, he had SBI में, let us assume he had PNB में. Now PNB का account and SBI का account was used for violating securities market. HDFC was his normal business bank account. No debit, no credit regarding share market. Okay, no debit, no credit regarding share market. Only SBI and PNB were used. So my question is, SEBI can attach the bank account on Nirav Modi, correct? They can attach HDFC, they can attach SBI, PNB, 2, 3, which one? They can attach only SBI and PNB for maximum 90 days. They can attach SBI and PNB and that too for maximum 90 days. Maximum 90 days. Then direct any intermediary or any person associated with the securities market in any manner not to dispose of an alienate an asset forming part of the transactions. So you can't sell the property, you can't destroy the property till the order of SEBI is come. The amount disgorged or the to a direction issued under the SEBI Act or the Securities Contract Act or the Deposit Act may be credited to IEPF and shall be utilized by the board in accordance with the regulation made thereunder. So basically whatever property has been confiscated, SEBI will sell it. Once they sell it, they will get the money and that money will be credited to IEPF, Investor Education Protection Fund. Investor Education Protection Fund. Cancel this. Cancel this. Then the SEBI have example. See the example. The SEBI have received certain information and complaints which may lead to believe that the Messrs DA brokers, a registered market intermediary, have violated multiple provisions of SEBI regulation. In such a case, SEBI may at any time by order in writing direct any person specified in the order to investigate the affairs of such intermediary or the persons associated with securities market and to report them in the board. Therefore, an order for investigation the affairs of the broker may be initiated. See, SEBI is godfather. SEBI can pass order against the company, against the stock exchange, against any intermediary, against any broker, anybody. SEBI is the godfather. Then additional functions. Cancel this. Now there are certain more powers. So it's all you read. There would be hardly any question on this. Okay, just we have to read this part. Okay, it shall be open to SEBI to inspect all reasonable times, books and accounts or documents to be maintained by the stock exchanges for a period not exceeding 5 years. So generally in companies we have studied a lot of time, company maintain the books for 8 years, right? Stock exchanges, you will maintain the books for 5 years, so they can inspect the books for 5 years. 5 years, not exceeding 5 years. Then, power of SEBI to call for information and explanation relating to the affairs of stock exchange. It shall be open to SEBI to call upon recognized stock exchange or any member thereof to ask for any information or explanation. So they can ask for information explanation. Okay, to appoint persons to make an inquiry. So SEBI has a power to appoint as number of persons as you want to conduct the inquiry, and upon the results of inquiry, SEBI will take the action. SEBI will bound the concerned person to produce documents before himself or other inquiry officer. So SEBI can ask any officer of the stock exchange, okay, to present the documents, books, papers to either to SEBI or to any inquiry officer. Then B, C, D, E, write their RTP. Power to delegate RTP. See, in the exam, they will ask only the question which have some numbers, which have some concept. These are just basic powers of SEBI. Okay, so we just need to read it, not an exam question. Okay. So stock exchange ka investigation for books of accounts is 5 years. This is one point which is important here. Okay, bank accounts can be attached, property can be attached for maximum 90 days. Only those properties can be attached or property or the bank account can be attached which are used in violation of SEBI. Okay, within 90 days you need to take the confirmation from this special code or else the property will be released. Read from here, from passing of an order till the last part. Till here. Okay, read. डन। अब देखो, now board to regulate or prohibit issue of prospectus, offer, document or advertisement soliciting money for issue of securities. Now basically when a company is coming with IPO, I hope you understand what's IPO, initial public offer for the first time when company comes up with the public issue. FPO basically means further public offer. Okay, so the rule is company will first prepare a prospectus and give it to ROC for registration. ROC will check and then give the approval. Once approval is coming, has come, then only the company can issue offer securities to the public. Okay, now here for the protection of investor, the board basically means SEBI may by regulation specify the matters relating to issue of capital, transfer of securities and other matters incidental, and the manner in such matters shall be disclosed by the companies whether general or special order. So they can prohibit, they can put restriction on the company from issuing prospectus or any offer document or any advertisement which is soliciting money from the public for the issue of securities. So SEBI has a power. So they can prohibit issue of prospectus, offer document, advertisement for soliciting money for issue of securities. Okay, not a concept, not a question. Then collective investment scheme. What it is? CIS, collective investment scheme. Now, have you heard about mutual fund? Mutual fund, that is basically CIS. So the old version was CIS, the new version is mutual fund. Mutual fund. So any arrangement which satisfies the condition which is referred below shall be called as CIS, collective investment scheme. Provided that any pooling of funds under the scheme or arrangement which is not registered with the board or is not covered under subsection 3 involving a corpus of 100 crores or more. 100 crores or more right there basically means minimum 100 crores shall be deemed to be CIS, shall be deemed to be CIS, shall be deemed to be CIS. Minimum 100 crore, minimum 100 crore, okay. Then any scheme or arrangement where the contributions or payments are made by the investors by whatever name called and are pooled together and utilized for the purpose of scheme or arrangement, it is called as what? It is called as collective investment scheme. The contributions or payments made are made to such scheme or arrangement by the investor with a view to receive profits, income, produce or property, whether movable or immovable from such scheme or arrangement. So basically mutual fund, what do? You invest, like I invest 100 rupees. SIP, you must have heard about SIP. People invest 100 rupees, 500 rupees, 600 rupees for a return, for an income, for an interest income. Okay, that is basically CIS only. The property contribution or investment shall involving form part of the scheme or arrangement, whether identifiable or not, is managed on behalf of the investor. So there is an agent, there is a fund manager we call, he manages on behalf of investors. The investors do not have to have day-to-day control over the management and operation of the scheme, because I have invested, so whenever I want to take exit, I can exit, but the investors cannot put any restrictions. Okay, you don't invest here, don't invest there, okay, sell now, buy now. No, the fund manager has a full power. Any scheme or arrangement made or offered by person satisfying the conditions as per the rules made under this act. So these are the conditions. Now, exception. Following scheme shall not be CIS. Following scheme shall not be CIS. What it is? Any offer made by a corporate society, under a corporate society, this can come in MCQ. Any offer made by a corporate society under Corporate Societies Act 1912. Deposits which are accepted by NBFCs. Deposits which are accepted by NBFCs. Contract of insurance to which the Insurance Act applies. Any scheme, pension scheme or the insurance scheme. Deposits under Companies Act. Deposits accepted by a needy company or mutual benefit society or a cheat fund company, or under which contribution are made in the nature of subscription to a mutual fund. So CIS is different, mutual fund is, it's a concept is same, but proper mutual fund, when you do SIP, it is called as mutual fund only. So it is not CIS or such other schemes as may be notified by CG. An example of CIS is a mutual fund. A mutual fund pulls money from multiple investors to invest in diversified portfolios such as stock, brokes, bonds and other financial instruments. So these are the examples. Mutual fund is one example. REITs, real estate investment, or private equity funds, ETFs, exchange trade funds and hedge funds. So CIS is the father, their example is there. Okay. So collective investment schemes are pooled investments such as like mutual fund, except CITs are tax exempt and maintained by fiduciary trustees pursuant to laws and regulations on the focus on retirement plan market. Unlike mutual funds, CITs are only available to institutional tax qualified investors like 401k plan. Let's read what it is. So while CITs and mutual funds both invest in passive and active portfolios of stocks and bonds, mutual funds generally have a higher cost structures and are overseen by the board that hires a registered investment advisor to manage the asset. Mutual funds must be sold through a registered broker dealer and are often offered to retail as well as institutional investors through a variety of distribution and intermediate channels like mutual fund sahi hai. All the cricketers keep on promoting it, mutual fund sahi hai. Mutual funds cannot vary their management fee but can create separate share classes to vary their distributions. So this is the difference. Understood? Then power to issue directions and levy penalty. So SEBI has a power in the interest of investors to prevent the affairs of any intermediary or to secure proper management. They can conduct inquiry, they can levy penalty. So board may issue directions to any class of persons referred in section 12 or associated with the securities market or to any company in the interest of investors or in the securities market. So board has a power to put any penalty, levy any penalty, conduct any inquiry. Cancel this. Read 345. Read 345. Done? Okay. Now come to investigation ka part. Okay. Now SEBI wants to investigate into affairs of, it could be a company, it could be an intermediary, it could be the securities of any company, and because SEBI is godfather, SEBI is godfather. Okay. Now, what are the grounds for investigation? What are the grounds for the issue of order of investigation? Where the board has a reasonable ground to believe that the transaction in securities are dealt in a manner which is detrimental to the interests of the investors. Detrimental basically means against. Or any intermediary like a stockbroker like Zero Dha, or it could be Motilal Oswal, Anand Rathi, or any person associated with the securities market has violated any provision of the act. So SEBI will, by an order, will order to investigate the affairs of such intermediary or the person associated with the securities market and to report thereon to the SEBI. Then furnishing of relevant documents. So when the investigation is started, every manager, MD, officer, employee of the company and every intermediary or any person associated with the securities market to produce to whom investigating authority or any person associated by it all the books, documents, records. Period. The investigating authority shall keep the books for how many months? For 6 months. And thereafter shall return the same to the intermediary from whom they have received the books. Okay. The investigating authority may call for the books, registered documents, and if they are needed again. Now, if it requires certification, it will put some marks on that. If the person on whose behalf the books, registered documents are produced requires certified copies of the books, registered documents, it shall give certified copies of such books, registered documents, or on whose behalf the books, registered documents, and records were produced. So, if you require certified copy, you will produce certified copy. Okay. The investigating authority will keep the books for 6 months and then they will send back. Okay. If it is needed again, then they can ask for again. Examination on oath. Oh, you come here. Oh, director MD, come here. Take on oath. Any person directed to make investigation may examine on oath any manager, director, officer, employee. Okay, he may ask them to come personally and take an oath. So this is basically a procedure. So SEBI can ask for investigation. Investigation will be done by investigating authority. Only point to remember is they can keep they can keep the books for 6 months. They can keep the books for 6 months. Penalty. To produce investigating authority any books register or to furnish any information or to before appear investigating authority for examination oath or for any questions. Okay, whatever you have contravened, sir, how much is the penalty? Imprisonment is up to 1 year, fine up to 1 crore or both. Up to 1 year, up to 1 crore or both. Up to 1 year, up to 1 crore or both. Or and also with a further fine which may extend to 5 lakh rupees for every day after the first default during which the failure or such refusal continues. Up to 1 year, up to 1 crore or both, and plus 5 lakh rupees per day. 5 lakh rupees per day. This is a penalty if you are not supporting investigation. Guys, this is the penalty when you are not supporting investigation. 6, 7, 8. Read. Okay. After considering the application hearing the investigating authority, the magistrate or the judge of the designated court may authorize investigating authority. See, in income tax also, whenever there is a raid, so the income tax officer can enter the premises, okay, but he requires an approval. The same way, SEBI ka investigating authority, if you want to enter into any premises, do search and seizure, okay, you require approval from the magistrate or the judge of designated court to enter with such assistance the place or places where the books are kept, to search that place or places in the manner specified in the order, to seize books, registered documents, okay. So boss, they can enter the premises, they can search the places, they can seize the books, okay, but they require approval from magistrate or district magistrate or the judge of the designated court. Provide the magistrate or the judge of designated court shall not authorize seizure of books, records of any listed public company or a public company which intends to get securities listed on recognized stock exchange unless such company indulges in insider trading. So if it's a public company or a listed public company, okay, you can't seize their books, you can't seize the book unless they are doing insider trading, unless they are doing some insider trading. So this is important. They can test you in MCQ. The investigating authority shall keep the custody of books, papers, documents for a period not later than the conclusion of the investigation, and they shall return once the investigation is over. They shall return once the investigation is over. Okay, and they can put what? Identification marks, which I told you they can put identification marks before returning. Every search and seizure shall be as per CPC 1973. So this is just a procedural part of investigation. Just remember that if you want to go for search and seizure, okay, search the premises, enter the premises, search the premises and seize the books, you will require approval from magistrate or the judge of district designated court. Okay, and in case if it's a listed company or a public company whose securities are about to get listed on recognized stock exchange, you can't seize their books. You can enter the premises, search the premises, but you can't seize the books. If they're doing insider trading, then you can seize the books. Till when you can keep the books? You can keep the books for maximum till the conclusion of the investigation. Once investigation is over, you have to return the book. This is after the searching. Here, when they're calling for the books, it is 6 months. Once you have entered the premises and you are searching and you are then seizing the book, then it is still the investigation. Okay. Read investigation. Done? So we have completed here. So we have completed, I think, section number 11C. Till 11C we have done. It's a very lengthy chapter, will go very slow. I will just keep on marking what are the keywords, what are the important points so that you can easily answer the MCQs. Understood? So this chapter is, the first part of the chapter is over. I think here we'll take around 6 to 7 classes wherein this, because it's a very lengthy chapter. Okay? Chalo. Bye guys, take care, enjoy and aim for a rank or 70 plus, whichever is earlier. We continue in the next class. Bye. Hi guys, what's up? Good morning. So we were doing SEBI and we have completed few part of the SEBI. I hope you guys remember little SEBI. In the meantime, open the notes. I will just quickly recall all the concepts. So SEBI ka year is 1992. In the SEBI, the body chairman and 5 other members would be sitting, who will be from the field of law, expertise in law, accounts, finance, stock exchange. Okay, whether you talk about company, whether you talk about the securities in the company, or whether you talk about stock exchanges, everything will be governed by SEBI. The godfather is basically SEBI. Okay, then we have done something about investigation. In investigation, the investigating authority can take into custody the books for maximum 6 months, and then they have to return it. They can call it again, but when they're returning, they can put identification marks also. Same way when we talk about investigation, in investigation the books would be seized till the time of authority, till the time of investigation. Once the investigation is over, you need to return the books. Okay, all the bank accounts, properties can be attached for a temporary period till the investigation is going on. Okay, and they have given a period there. 90 days. They can attach it for maximum 90 days. They can attach it for maximum 90 days. They can attach it for maximum 90 days. Okay, and only those bank and property would be attached which is involved in the contravention. Okay, if a person has 5 bank accounts but other 4 are not involved, they can't be attached. They can be attached for maximum 90 days. Cool. So we start from the concept of 11D. 11C we have done. We are starting with 11D. Cease and desist proceedings. Please write that important. Ceased. Cease basically means stop, and desist basically means to disassociate somebody. Desist basically means to disassociate. It says if the board basically means your SEBI finds that an inquiry is to be made that any person has violated or is likely to violate any provision of this SEBI Act or any rules made thereunder, it may by an order require such person to cease and desist from committing or causing such violation. That is, stop and disassociate. Cease basically means to stop and disassociate from committing or causing such violation. Provided the board shall not pass an order in respect of any listed company or a public company other than the intermediate specified in section 12 which intends to get listed on any recognized structure unless the board has reasonable grounds to believe that company has been indulged in insider trading or market manipulation. Has reasonable grounds to believe that such company has indulged in insider trading or market manipulation. So it's very simple. If SEBI finds out that you have violated something or you will be violating some provisions of the SEBI Act, so they will pass an order to cease and desist from committing such or causing such violation. Okay, they can't pass the order in case of any listed public company or unlisted public company whose securities are about to get listed on any recognized stock exchange unless the SEBI has a grounds to believe that such company was indulged in 2 things: insider trading or price manipulation. Remember this. Okay, important answer. Next, registration certificate, section number 12. Registration certificate, section number 12. It says the persons who are authorized to buy or deal in securities. Who can do it? It's only a read part. Stock broker, sub broker, share transfer agent, banker to an issue, trustee of trustee, registrar to an issue, merchant banker, underwriter. So these people are authorized. To deal in security only if they have a certificate. Only if they have a certificate of registration. Who will give? Sir, board will give. Board basically means SEBI will give. Then the board may by notification specify the person who shall buy, sell or deal in securities. So some other people also board can notify, like for example, they can notify depository participant, custodian of securities, any foreign institutional investor or any credit rating agency or any other intermediary by notification. Okay, and they can also deal in security provided they also have a certificate of registration. Now, every application of the registry shall be as per the rules on unpayment of such fees. Suspension. The board may by order suspend or cancel certificate of registration in such manner. But before cancelling, what they will give a reasonable opportunity of being heard. So in this section, section number 12, there was no as such concept, no concept here. Okay. So this is also reads, right? There RTP, read if time permits. Read if time permits. Then prohibition of manipulative and deceptive devices, insider trading and substantial acquisition securities or control. Prohibition. Prohibition basically means, sir, allowed or not allowed? Not allowed. Prohibition basically means what? Not allowed. Of manipulative and deceptive devices. Manipulative and deceptive, that means you have designed a system wherein the price of the securities will change and you will be in favor as compared to others. Insider trading. Okay, if I am a director of a company, I know all the facts about the company and I can ask my friends relative to buy and deal in the securities. And substantial acquisition securities or control. Purposefully I am acquiring the control and then I will sell at a very high price and people will also buy, like for example Vijay Kedia. Vijay Kedia is a very big investor. Okay, like our chartered accountant late Rakesh Junchunwala, now he is no more. Okay, so if he is buying a lot of securities, lot of shares in one company and later on he will sell, because what happens when a big investor buys, normal public also keeps on buying, so the price rises. Once the price reaches his thought process that okay, this is my price, he will sell. So when the big investor sells, the price falls. Eventually who is getting a loss? The small investors. So basically you are manipulating the stock there, so it is prohibited. No person shall directly or indirectly use or employ in connection with the issue, purchase or sale of any securities listed or proposed to, or who is proposed to be listed on stock exchange, any manipulative or deceptive device or contraventions in contravention of the provision of this act or rules made thereunder, or employ any device, scheme or artifice to defraud in connection. That means you can't do any cheating out here. Or engage in any practice, course or business which operates or would operate the fraud to deceit upon any person, I mean to cheat any person in connection with the issue or dealing in securities which are listed or which are proposed to be listed, or deal in securities in possession of material or non-public information, or communicate such material or non-public information to any other person. You must have seen in Telegram, lot of all the stock influencers, they keep on advising, but now SEBI has banned all those people. No, you can't give those tips in the Telegram channel, and if you are doing it and if you have made again, we will try to recover it. If you have heard about, one second, I'll just show you one latest. Asmita Shah Stock Booking Academy. She made, I think, 80 crores. Here you go. See, Asmita Patel, YouTuber fined by SEBI over illegal. Let's read this. YouTuber fined by SEBI over illegal stock tips. She's a girl. You must have seen a lot of time on Instagram. Asmita Patel, a well-known influencer and YouTuber dubbed the she-wolf of the stock market, has been banned by SEBI for allegedly offering unregistered investment advice under the guise of stock market education. Her trading school, Asmita Patel Global School of Trading, along with associate entities, is accused of collecting 104 crores through misleading investment programs. SEBI has impounded 53.6 crores and barred Patel and others from trading in securities. So she is barred. She is a girl. So you can read it out, Asmita Patel. So see, if you read 120 page order detail how Patel School was providing buy and sell recommendation through Telegram channels and activity that legally falls under registered investment advisory services. The acts of Asmita Patel Global School of Trading makes it evident that it was providing investment advice and research analysis service to students, investors and participants for a consideration under the pretext of imparting education. Following complaints from 40 students who suffered financial losses despite following a strategy, SEBI issued a ban on Patel and 5 others from trading in securities. So SEBI is the governing body, okay. So, or acquire control of any company or securities more than the percentage of equity share capital of a company whose securities are listed or proposed to be listed. So, SEBI will prohibit it. So, till now there is no concept as such, it is just knowledge, okay, that SEBI is a power, SEBI can put restrictions, put prohibitions, lot of things. Wherever there is a probable question, I will let you know to mark, okay. Here also RTP. Then, finance, accounts and audit. The CG after due appropriation made by the parliament by law in this behalf, make the board grant such sum of money as the CG may think fit. So they can give, who can give, CG can give grant to the SEBI. There shall be constituted a fund to be called as Securities Exchange Board of India General Fund, and there shall be credited to all grant fees, charges received by the board under this act. All sum received by the board from other sources. Whatever money you receive, it will be transferred to where? SEBI General Fund. SEBI General Fund. Underline that, SEBI General Fund. The fund shall be applied for what? It shall be applied for salaries, allowances, expenses of the board and expenses on other objects and purpose authorized by the act. So the money here in this fund will be used for all the basic admin purpose of the SEBI. The board shall maintain proper accounts and other records and prepare an annual statement in such form as may be prescribed by CG and shall be in consultation with CAG. So basically CAG will be doing the audit, Comptroller and Auditor General of India, Comptroller and Auditor General of India. Audit. The accounts of the board shall be audited by dash Comptroller and Auditor General of India at such intervals as may be specified by him, and any expenditure incurred in connection with such audit shall be payable by the board to the CAG. So SEBI will pay the payment, audit fees. Rights and privileges. The CAG and any other person appointed by him will have same rights and privileges in connection with such audit as the CAG generally has in connection with the audit of government companies. So whenever CAG goes for government company, government corporation, government audit, so whatever rights and privileges he has, he will have the same rights and privileges here when he audit the SEBI. Then the accounts of the board as certified by CAG or any other person appointed by him shall be laid forwarded to the central government, shall be forwarded annually to the central government, and it shall be laid before each house of the parliament. Each house means basically two houses. Lok Sabha, Rajya Sabha, in English we say upper house and lower house, okay. So you present it. So CAG you will do the audit and you will present it annually to the CG, because audit is generally done annually, and you will do audit annually and present it to the CG, and the CG will lead it before both the house of parliament. So till here as such there was no concept except point number 7, cease and desist wala provision, okay. From here you will read till before penalties, then we're gonna do penalties. Read. Done. Penalties. Now from here you mark this as important. Penalty for failure to furnish information written section 15A. Penalty for failure to furnish information written etc. section 15A. So SEBI must have asked some written some information, you have not given it. How much is the penalty? So if any person is required under this act fails to furnish any document, return, report to the board, fails to file any return, furnish any information, books or other documents, or fail to maintain books, accounts or records, how much is the penalty? It is common, same penalty. Please mark this. Minimum 1 lakh, but which may extend to 1 lakh rupees per day subject to maximum 1 crore. 1 lakh extend to 1 lakh rupees per day subject to maximum 1 crore. 1 lakh rupees per day subject to maximum 1 crore. It's a common penalty. 1 lakh rupees minimum, 1 lakh rupees per day subject to maximum 1 crore. Same penalty. Penalty for failure for any person to enter into agreement with the clients. So if I open my account with Zerodha or Kotak Securities, okay. So before entering into, before dealing in securities, I need to enter into a contract. So all the stockbrokers, you should make sure that you enter into an agreement with the clients. If you have not entered into the agreement, same penalty it is. Minimum 1 lakh rupees per day subject to maximum 1 crore. 1 lakh rupees per day subject to maximum 1 crore. Now, penalty for failure to redress investor grievance. Again 15C, same penalty. If you are not redressing investor grievances, that means you are not solving investor grievances, it is 1 lakh rupee, same penalty. 1 lakh rupees per day subject to maximum 1 crore, same penalty. Now in case of mutual funds, now what is the penalty for mutual funds? It says required under this act or any rules or regulation made thereunder to obtain a certificate of registration from the board for sponsoring or carrying on any CIS scheme. If you are dealing in this CIS scheme without obtaining certificate of registration, same penalty it is 1 lakh rupees per day subject to maximum 1 crore. Registered with the board as a collective investment scheme including mutual funds for sponsoring and fails to comply with the terms and condition of the certificate, still same penalty. 1 lakh rupee per day subject to maximum 1 crore. Register with the board as CIS, fails to make an application for listing of the scheme, fails to without certificate of registration. Number 2, you were given certificate but you failed to comply with the conditions. Number 3, you failed to get listed. Okay. Failed to dispatch unit certificates to the investors. Fail to refund the application money paid by the investor within the period specified in the regulation. Fails to invest the money collected by CS in the manner within the specified in those regulations. Everywhere it is same penalty. 1 lakh rupees per day subject to maximum 1 crore. So any penalty right now, whatever we have studied, it is whatever default you will do. If you are not maintaining any document, if you are not filing any return, if you are not maintaining books, okay, if you are not entering into agreement, or any penalty regarding mutual funds, everywhere it is 1 lakh rupees per day subject to maximum 1 crore, Then penalty to observe rules and regulation by an asset management company, AMCs, okay. Same penalty it is 1 lakh rupees per day subject to maximum 1 crore. Still till now whatever questions comes, it is 1 lakh rupees per day subject to maximum 1 crore, okay. Circle this different penalty. Penalty for default in case of alternative investment funds, infrastructure investment trust and real estate investment trust. How much is the penalty? 1 lakh rupees, but which may extend to 1 lakh rupees per day subject to maximum 1 crore, or 3 times the gain made, whichever is higher. So maximum is 1 crore or 3 times the gain made, which is higher. How do you remember? 3 times, right? 3 times. So 1, 2, 3. Alternative investment funds, infrastructure investment trust and real estate investment trust. Alternative investment funds, infrastructure investment trust and real estate investment trust. Okay, so it is 1 lakh rupees minimum, 1 lakh rupees per day subject to maximum 1 crore, 1 crore ke beside will write or 3 times again whichever is higher. So minimum 1 lakh rupees per day subject to maximum 1 crore or 3 times again whichever is higher. So 3 times is written besides maximum, Penalty for default in case of investment advisor and research analyst. So all those people, research analyst and investment advisor, if you are giving wrong advices, if you are not complying with the direction issued by the board, same penalty, 1 lakh rupees per day subject to maximum 1 crore. 1 lakh rupees per day subject to maximum 1 crore. In case of stock brokers, if stock broker is not giving me the contract note basically means the bill, I bought 10 shares. So the 10 shares ka details you need to give me within 24 hours. If you have not given, same penalty, 1 lakh rupees per day subject to maximum 1 crore. Fails to make the payment to the amount due to the investor. If he has sold, so he need to get the money back. The stock broker is not selling, not sending the money. 1 lakh rupees per day subject to maximum 1 crore. An amount of brokerage which is in excess of the brokerage charged. Amount of brokerage which is in excess of the brokerage specified in the regulations. How much is the penalty? 1 lakh rupees but which may extend to 5 times the amount of brokerage charge. This is a different penalty, please underline this. 1 lakh rupees but which may extend to 5 times the amount of brokerage charge in excess of the specified broker whichever is higher. ₹1 lakh or 5 times the brokerage charge which is in excess whichever is higher. Now, example 3. Aryan Capital is a stockbroker member of National Stock Exchange. Company has issued contract notes for the client. Wahid complained to SEBI the company has failed to issue contract note in the form in the manner specified by NSE. Contract note not given. So it is minimum 1 lakh rupees. 1 lakh rupees per day subject to maximum 1 crore whichever is subject to maximum 1 crore. 1 lakh rupees but which may extend to 1 crore where the contract note was required to be issued. Minimum 1 lakh, maximum 1 crore. Minimum 1 lakh, maximum 1 crore. Only this brokerage charges ka different penalty is there and this AIF mein. Alternative investment fund, infrastructure investment trust and real estate investment trust. Then penalty for insider trading, very important, very repetitive. He shall be liable to a penalty of more than 10 lakh rupees, that is 10 lakh rupees minimum, or 25 crore rupees, or 3 times the profit made whichever is higher. 10 lakh to 25 crores or 3 times the profit made whichever is higher. 10 lakh to 25 crores or 3 times the profit made whichever is higher. 10 lakhs to 25 crores or 3 times the profit made whichever is higher. If I am doing or if I ask somebody to do insider trading on my behalf, okay, and we will share the gain, I am liable for minimum. We all both are liable for 10 lakh rupees or 25 crores or 3 times the profit made whichever is higher. So 10 lakh is minimum. Okay, sir, if I am sharing some information, some vital information with a view to get the gain or share the gain, I am liable for insider trading. But if I am sharing some some ordinary course business information, like for example AGM ka date, I am sharing AGM ka date. So AGM ka date I need to share. I am a director of a company, I need to tell about AGM ka date, okay. So I am sharing some information which is allowed in ordinary course of business. Then I am not guilty of insider trading. Okay. Mr. Akash filed a complaint to SEBI that Mr. Nimish Vidya, CFO of the company, has passed an information to his close relative regarding confidential deal of the company which will take place soon. Confidential. The intention of Mr. Nimish was to get profit from the share trading. Now, how much he will be liable for? 10 lakh rupees to 25 crores, 10 lakh rupees to 25 crores, or 3 times the profit made, whichever is higher. Then, penalty for non-disclosure of acquisition of shares and takeover. How much is the penalty? If any person who is under this act or any rules thereunder fails to disclose the aggregate of his shareholding in the body corporate before he acquires any shares of that body corporate, or make a public announcement to acquire shares at minimum price, or makes a public offer by sending a letter of offer to the shareholders of a company, or make payment who sold the shares pursuant to the letter of offer, he shall be liable to fine of same penalty 10 lakh rupees to 25 crores or 3 times the profit made, whichever is higher. So if you are already holding a shares in the company and you are acquiring more share, you fail to make a public announcement, okay, you fail to make a public offer by sending letter of offer, you fail to make payment of the consideration to the shareholders pursuant to who sold the share pursuant to the letter of offer, okay, you will be guilty of 10 lakh rupees to 25 crore rupees or 3 times the profit made, whichever is higher. So basically, when you acquire shares in a company where you are already holding, like for example, if I am investing in a startup, the startup got listed, I am buying more shares in that, I need to give letter of offer, okay, I need to announce that I will be buying shares in this company, and people who are ready to sell, they will sell the shares to me, I need to make them payment. If I am not making the payment or letter of offer is not given or public announcement is not given, then I am guilty of 10 lakh rupees to 25 crores or 3 times the profit made, whichever is higher. Penalty for fraudulent and unfair trade practices. Minimum 5 lakh or 25 crores or 3 times the profit made, whichever is higher. Instead of 10 lakhs, it is 5 lakhs. So this is, see, the first common penalty is 1 lakh per day subject to maximum 1 crore. AIF made came through 3 times the profit made, whichever is higher. Then we got brokerage made was 1 lakh to 5 times the brokerage charge, 1 lakh to 5 times the brokerage charge. Then insider trading was different, 10 lakh to 25 crores or 3 times the profit made, whichever is higher. Then non-disclosure of acquisition of shares and takeover, it's same as insider trading. Unfair trade practice made is 5 lakhs to 25 crores or 3 times the profit made, whichever is higher. Okay. Penalty for alteration, destruction of records, failure to protect the electronic database of the board. Somebody is hampering the database of the SEBI. Okay. How much is the penalty? 1 lakh rupees, which may extend to 10 crores or 3 times the profit made, whichever is higher. So this is a different penalty. So if you hamper SEBI ka database, you halt the trading, you switch off the main system, okay, you will be guilty 1 lakh rupees to 10 crore rupees or 3 times the profit made, whichever is higher. Then common penalty, where no separate penalty is given, how much is the penalty? Common penalty 1 lakh rupees, which may extend to 1 crore rupees. See, 1 lakh and 1 lakh per day. So minimum is 1 lakh per day. Even if you don't remember it, it's okay. Maximum is how much? 1 crore, na? So 1 lakh rupees maximum 1 crore. So 1 lakh rupees per day also you can use. If you are not using, it's okay, because maximum is 1 crore. So any penalty between 1 lakh to 1 crore, 1 lakh to 1 crore. It could be 3 lakhs, it could be 5 lakhs, it could be 7 lakhs, it could be 9 lakhs, it could be 10 lakhs. So it can be assumed that is 1 lakh per day also included in that. So it is 1 lakh, maximum 1 crore. Okay, this is the common penalty. Read all the penalties. So I would say one penalty is 1 lakh per day subject to maximum 1 crore. Second penalty was different, was this one, F wala point. Third penalty different was the brokerage. Fourth was insider trading and this non-disclosure of the acquisition of shares. Fifth was unfair trade practice, unfair. And sixth was alteration, destruction in the record. So there are 6 different penalties. Okay. Read. Then we do adjudication. Read 11th. Done? Now, power to adjudicate. So, for the purpose of all the sections of 15 A, B, C, D, E, 15 EA, 15 EB, F, G, H, HA and HB, the board may appoint any officer not below the rank of division chief to be an adjudicating officer. So rank not with the rank of a division chief to be an adjudicating officer who will conduct the inquiry and who will levy the penalty. Adjudication basically means who will levy the penalty. So an officer not with the rank of a division chief to be an adjudicating officer. Then holding of an inquiry. The adjudicating officer will have a power to summon and enforce attendance of any person. This is a procedural part. You can skip this. Order passed by adjudicating officer if it is not justified. The board may call for and examine the record of any proceeding if considered that the order passed by the adjudicating officer is erroneous. That means the error is there or it is not in the interest of the securities market. It may pass an order enhancing the quantum of penalty if that circumstances of the case so justify, provided no such order shall be passed unless a portion of being heard is given to the opposite person, provided nothing shall in this subsection shall be applicable after the expiry of 3 months from the date of the order passed by the adjudicating officer, or the order disposal of the appeal under section 15T, whichever is earlier. So it says basically adjudicating officer, if he has passed the order and it is not justified, so the SEBI can increase the penalty, but if they are increasing the penalty, they will give an opportunity of being heard. But if 3 months have passed, then they can't change the order. Whatever order adjudicating officer has passed, it will be final. Okay, so this is basically read. Then factors to be considered before levying the penalty. This is same as Companies Act. So the repetitive nature of default, the amount of loss caused to an investor, group of investor, amount of loss. So you can write loss, repetitive nature, amount of disproportionate gain or unfair advantage where quantified made as a result of a default, amount of disproportionate gain. So gain, loss, repetitive nature, gain, loss, repetitive nature, gain, loss, repetitive nature. Then next is establishment, jurisdiction, authority and procedure of SAT. So now SEBI Act is over. Now they have given the decision that you are guilty, but you are not happy with the decision. So you have a power to file an appeal. So you go and file appeal to SAT, Securities Appellate Tribunal. Securities Appellate Tribunal. Then it says the CG by notification will establish a tribunal to be known as the SAT. The CG shall specify in the notification the matters and places in regard to SAT. How many people will sit in SAT? It shall consist of a presiding officer and such number of judicial members and technical members, JM and TM. This we have done in NCLT. So your presiding officer, JM and TM as a CG may specify. Now, the jurisdiction of SAT may also be exercised by the benches. A bench may consist of presiding officer of the SAT with 2 or more judicial members or technical member as it may deem fit, provided every bench shall have at least 1 JM and 1 TM. So 1 presiding officer plus 2 or more judicial or technical members. So 1 presiding officer with 2 or more judicial or technical members as it may deem fit, provided every bench consist shall include at least 1 JM and 1 TM, 1 JM and 1 TM. Okay, so presiding officer is there, so you can have 2 JM, 2 TM. Okay, but it says 1 GM and 1 TM should be mandatorily there. So 1 presiding officer is there, 2 GM, this is 0, not allowed. 1 GM, 1 TM has to be mandatory there. So can we have 2 GM and 1 TM? That is allowed. 1 GM and 1 TM mandatory has to be there. 1 GM and 1 TM has to be there. The benches of the SAT shall ordinarily sit at Mumbai and may constitute at other places as the CJ may specify. The presiding officer may transfer a JM or TM of the SAT from one bench to another. So Mumbai say they can transfer to Delhi, Delhi say they can transfer to Calcutta, Calcutta they can transfer to Bangalore, Bangalore say they can transfer to Chennai. Now, here we talk about the appointment qualification for presiding officer and members of SAT. Members may it is JM and TM. A person shall not be qualified as appointment as the presiding officer or GM or TM unless he, this is important, he has been a judge of Supreme Court or Chief Justice of High Court or judge of a High Court for at least 7 years in case of presiding officer. Either you are a judge of Supreme Court or Chief Justice of High Court or a judge of a High Court. Either you are a judge of Supreme Court or Chief Justice of High Court or a judge of High Court for 7 years. So judge of Supreme Court is one factor, Chief Justice of High Court is one factor, and judge of High Court for 7 years. Judge of High Court for 7 years in case of presiding officer. Now when you talk about JM, he has to be judge of High Court for at least 5 years. Judge of High Court for at least 5 years for JM. For TM, has been a secretary or additional secretary in the ministry or department of the CG or any equivalent post in the CG or SG, or person of ability, integrity, standing and having a knowledge of experience of minimum 15 years in a financial sector including securities market or pension funds or commodity derivatives or insurance. So let's do it again. When you talk about presiding officer, either you are a judge of Supreme Court or Chief Justice of High Court or a High Court judge for 7 years. When you talk about JM, judge of a High Court for 5 years. When you talk about TM, either you are a person like Ministry of Finance or Ministry of Corporate Affairs or Ministry of any department, you are a secretary or additional secretary, or a person of ability, integrity, having knowledge of minimum 15 years experience. Then the presiding officer and the GM of the SET shall be appointed by CG in consultation with Chief Justice of India or his nominee. The presiding officer and the GM shall be appointed by CG in consultation with Chief Justice of India and his nominee. Appointment of TM. The TM shall be appointed by the CG on the recommendation of Search and Selection Committee. Very differential answer. The presiding officer and the GM shall be appointed by whom? By the CG in consultation with Chief Justice of India and or its nominee. However, the TM shall be appointed by the CG but on the recommendation of selection, Search cum Selection Committee. How many people will sit in Selection Committee? Sir, Selection Committee में these people will sit. Presiding officer of SAT, Secretary Department of Economic Affairs, that's member, Secretary Department of Financial Service member, Secretary Legislative Department of Secret or Secretary of Legal Affairs as a member. So presiding officer, Department of Economic Affairs, Department of Financial Service, Legislative Department or Legal Affairs ka department, okay. Then the Secretary, Department of Economic Affairs shall be the convener of Search cum Selection Committee. The Search cum Selection Committee shall determine its procedure for recommending the names of the person to be appointed under subsection 1. So understand, the presiding officer and GM shall be appointed by the CG on the consultation with Chief Justice of India or his nominee. So technical members will be appointed by CG on the recommendation of Search cum Selection Committee. In Search cum Selection Committee, how many people will sit? 4 people. SAT का president, secretary of economic affairs, financial service and legal department से. अच्छा, economic affairs का the secretary will be the convener of the selection committee. Validity of appointment of presiding officer and the members of SAT. So same point what we have done when we did the SEBI ka body. No appointment of the presiding officer, GM or TM shall be invalid merely because of a reason of the vacancy or defect in the constitution. All will be valid. Okay. A member or part-time member of the board or the insurance regulatory and development authority of the pension fund regulatory and development authority or any senior person equivalent to the executive director in the board shall not be appointed as a presiding officer or a member of SAT during his service or tenure as such with the board or with such authorities or within 2 years from the date on which he ceases to be in the board. If you are a member in the SEBI, okay, at the same time you can't be a member of SAT. Okay, you have left SEBI, still you can't be a member of SAT for how many years? For 2 years. 2 years ka restriction. This right there RGB. Tenure. The presiding officer, JM, TM shall hold office for 5 years, another term of 5 years. Then maximum age 70 years. In SEBI it was 65 years, here it is 70 years. SAT it is 70 years, okay. So it is 5 years or 70 years which is earlier, that is 5 years or 65 years whichever is earlier. Remember the difference, 5 or 65 in SEBI, in SAT it is 5 or 70 whichever is earlier. HI read RTP. HNI RTP. Resignation and removal, important. Removal also important. So first point is resignation, second one is removal. The presiding officer or member of the SAT may, by giving a notice to the CG, may resign from his office. Same rule, until the expiry of 3 months, or his successor is appointed, or until the expiry of his term, whichever is earlier. So you can't say I will not come from tomorrow. You have to give 3 months ka period, or successor is appointed, somebody else is appointed, or the term is over, whichever is earlier, whichever is earlier. If the term is over, okay, imagine your term is getting over on 28 August 26. You gave notice on 25th Jan 2026, let us assume, okay. Successor was appointed on, so this is term, this is notice, successor 20th Feb 26. So if I do 3 months from here, this is 24th 1 to 2 2 to 3 3 to 4 4 26. So 28th August or 24th April or 20th Feb, whichever is earlier. So he has to go on 20th Feb. So it is term completion or successor, or 3 months from the notice, whichever is earlier. Term completion or successor, term completion or successor, or 3 months, whichever is earlier. Removal. Who appointed? CG. Who will remove? CG. The CG may, after inquiry made by judge of Supreme Court. So CG cannot remove directly. Inquiry has to be done by the judge of Supreme Court. Can remove the presiding officer, GM or TM of the SAT if he is insolvent, physically, mentally incapable, or convicted of any offence in the opinion of CG, okay, or in the opinion of CG, abuse his position, or has acquired financial interest or other interest which is affecting his function. Okay, he can't be removed but unless he has been given a opportunity of being heard. For DNE, there has to be a opportunity of being heard. ABC, insolvent, physically, mentally incapable, convicted, that there is no opportunity of being heard. That's logical. CG is authorized to regulate the procedure of investigation. The CG may, by rules, may prescribe the procedure for investigation in case of misbehavior or incapacity of the presiding officer or any member. So CG you can't remove directly. There has to be an inquiry done by whom? Judge of Supreme Court on this grounds. So there has first, this ground has to be attracted, either A or B or C or D or E. In D, you will give opportunity of being heard. Then Judge of Supreme Court will say, okay, yes, you can remove. Then only CG can remove. Then only CG can remove. Understood? So appeal ka part is pending. We have just understood SAT. SAT answers are very much repetitive. Who can sit in SAT? How many people can sit in SAT? JM, TM, what it is, and who will appoint JM, who will appoint TM, who will appoint president. Okay, how many years ke liye they can sit in the office, and when they're resigning, what is the period rule? What is when they remove the what is the rule? Very repetitive answers. Okay, read this much. From power to adjudicate. Read. Done? Cool. So we stop here. So we have completed set ka part. I mean half of the set ka part. Who will sit in the set? What is the qualification? Or when they want to resign? What is the rule? When they are removed? What is the rule? Okay. Then the later part is about the appeal ka part. We do it in the next class. Okay. I hope you have understood this much. Cool. Aim for rank or 70 plus, whichever is earlier. Bye guys. Take care. Hi guys, what's up? Welcome back to the class, and we were doing our SEBI, and we have done major content of the SEBI Act, and we are left with some regulations. Okay, so quickly open your book so that we start and we do some more content today. I think in the previous session we have started with the Establishment Jurisdiction Authority of SAT. Okay. In the meantime, I'll quickly recall the provisions so that you are updated with the provisions. The SAT will have a presiding officer and such number of JM and TM as a CJ may determine. Then the presiding officer of the SAT along with the two or more JM or TM as he deemed fit, every bench should have one JM and one TM. There should be one JM and one TM. Okay. The office of the SAT would be at Mumbai, the register office, and such other places as the CJ may specify. Then the presiding officer may transfer a JM or a TM of the SAT from one bench to another. From one bench to another, they can shift. Now, qualification. Sir, very important point. If you are talking about the presiding officer of the SAT, he either has to be a judge of Supreme Court or a chief justice of a high court or a judge of a high court for at least 7 years. So either straight away judge of Supreme Court or chief justice of high court, or if you were a judge of a high court for 7 years, then you can become a presiding officer of SAT. Okay. Is or has been a judge of high court for at least 5 years for a GM. So if you are a judge of a high court for 5 years, you can become the GM. For technical member, either you are a secretary or additional secretary in any department or ministry of the government or an equivalent post, or you are a person of integrity ability having experience of minimum 15 years, ka experience. Then the presiding officer and the GM shall be appointed by CG in consultation with Chief Justice of India. By CG in consultation of Chief Justice of India. Okay. However, the TM shall be appointed by CG in consultation with the search cum selection committee. These people will be sitting in the search cum selection committee. These people will be sitting in search cum selection committee. Okay. What is the validity of their appointment? Okay. So if they have given any decision, but the constitution of SAT is defective, decision would be valid. Even if they have resigned, the decision will be valid. Okay. Tenure. The presiding officer of GM and TM of SAT shall be 5 years, or they can be reappointed for another term of 5 years. The maximum age is 70 years. There it was 65 years, right? Here it is 5 years. 5 years and 70 years. Then resignation and removal. It can't be directly removed. It can't be directly removed. You can't directly get removed or resigned. There is a period of 3 months. There is a period of 3 months. So until expiry of 3 months or the successor appointed or the completion of term, whichever is earlier, provided the presiding officer, technical member or GM can be removed only after an inquiry of the judge of Supreme Court. Okay, and this should be the ground. This should be the ground. However, for DNE, there has to be reasonable opportunity of being heard. Unless he has a reasonable opportunity of being heard for DNE. Till here we have done. Okay, I hope you remember the content. Now we are moving on to appeal to SAT. So from here we start. Okay. Now please take a pen or pencil in your hand, because there would be a lot of days which we need to mark. It may come as a MCQ. Any person aggrieved by the order of board. Any person aggrieved by the order of board basically means SEBI, or made by an adjudicating authority under this act, or by Insurance Regulatory Development Authority IRDA. Any person who is aggrieved by this authority shall file an appeal to SAT within 45 days. They will file an appeal to SAT within 45 days. Circle 45 days. From the date on which the copy of the order made by the board or adjudicating officer or the IRDA or pension fund, whichever it was pending, okay, from the date you will have a power to file an appeal within 45 days. Extension. If there is a sufficient cause, there is an extension of 45 days. The SAT may entertain an appeal after the expiry of 45 days if it is satisfied there was sufficient cause for not filing the appeal within that particular period. So they have not given the period for extension. They said the extension is there. So ideally the extension is same only. Whatever is the period, That much kahi only extension is given. Generally, it is that only. Now, on receipt of the appeal, what will SAT do? SAT may, after giving parties to the appeal an opportunity of being heard, may pass such order as it may deem fit. It may modify the order, it may set aside the order, it may cancel the order, it may approve the order, whatever it is. Then they will forward the copies to the parties. The SAT may forward a copy of the order made to board or IRD or pension for authority as the case may be, and to the concerned adjudicating officer. Time period for disposal of appeal, it is 6 months. 6 months from the date of the receipt of appeal. So SAT will give the decision within 6 months. You have a power to file appeal within 45 days. Extension is allowed, but days they have not given. SAT will dispose of the case within 6 months from the date of the receipt of appeal. Then appeal to Supreme Court. Any person who is aggrieved by the order of SAT may file an appeal to Supreme Court within 60 days from the date of decision of SAT. If there is any question of law, you can go to Supreme Court only on the question of law. You can go to Supreme Court only on the question of law. Then Supreme Court may give extension. Supreme Court may give extension for a period not exceeding 60 days. So extension 60 plus 60. Okay. So you draw a diagram here. Appeal to SAT. This is 45 days. Extension is there. SAT will dispose within 6 months. Aggrieved by SAT, go to Supreme Court. (60 days) extension 60 days. 60 days, 60 extension 60 days. Okay. Bracket may write question of law. Bracket may write question of law. Done? Done appeal ka part? Cool. So point number M, that's section 27, says contravention by company. I'll just read for you and I'll just explain in short. It's basically RTP type. So whenever a company is doing a contravention, whenever the section says a company has contravened, so it means company to have contravened plus whoever is the officer involved, the director, the employee of the company, all those people would be also responsible. So whenever I say company is responsible, company basically means your director. Director is responsible here. Okay, so this is RTP type. Recovery of amounts. Here company also means any body corporate includes a firm or other association of individuals. Direction in relation to firm basically means a partner in the firm. So whenever we say company, company also includes firm, and when I say director, director also includes partner. So that is basically you refer to that person that we say company is responsible. So basically directors are also responsible. When I say company, company also includes partner, partner also includes firm, firm also responsible, partner also responsible. Okay. recovery of amounts. Now, if a person fails to pay the penalty imposed under this act or fails to comply with any directions of the board, then what the board can do? The board can adopt any one or more of the following modes. They can recover. How? They can attach and sell person का movable property, attach and sell person का immovable property, attach the person का bank accounts, arrest the person in his detention in the prison. So they can attach both movable, immovable, attach bank statement and arrest the person. E. Appoint a receiver or manager for the movable or immovable property. So either they can sell the property, movable, immovable. They can appoint a receiver for the management of the property, arrest the person and attach the bank account. And here, which act will follow? Income Tax Act 1961. The provision of Income Tax Act 1961 recovery proceeding, we will follow the procedure. For the procedure is as per Income Tax Act 1961. But they can do again attach movable, immovable property and sell at movable, immovable property. Okay, then appoint a receiver for movable and immovable to manage movable and immovable property. Then arrest the person and attach the bank account. Either of it they can do it. Now, the persons, there's a question on this also. The person's movable or immovable property or monies held in bank account shall include any property or monies held in the bank account which has been transferred directly or indirectly on or after the date where the amount specified in certificate become due by the person to his spouse, to the minor child, son's wife, son's minor child, otherwise then for adequate consideration, that is inadequate consideration, and which is held by in the name of those people, minor child, son's minor child, even after the date of attainment of majority by such minor child or son's minor child as a case may, continue to be included in the person's movable or immovable property. Now, imagine the order was passed on 10th July 26. Okay, 10 July 26. Now, somebody has transferred on 10th June 26. Somebody has transferred on 15th June 26. To whom? To the spouse, the minor child, son's wife or son's ka minor child. They have transferred the property. So, that property would be seized. However, if, and that too for inadequate consideration. If you have transferred here, if you have transferred before, whether it's adequate or inadequate, SEBI will not come in picture. SEBI Act will not come in picture. That is, some other act will come. But here the property will be seized only if it has been transferred directly or indirectly on or after the date when the amount specified in the certificate had become due. So when the amount became due, and so that people will not sell the property, the act will, SEBI people will not sell the property, you sold the property, you transferred it to your spouse or your minor child or your son's wife, okay, or son's minor child, okay, for inadequate consideration, and it is held in their name, then that can be attached, but if it is transferred before, it can't be attached. Remember this. So because here you have transferred for inadequate consideration with a purpose that SEBI people will come, they will sell the property and you will say it is not my property, it is with my son's ka minor child or my wife or my minor child or my son's ka minor child. I am not having it, so they can't sell it. But here you have transferred it purposefully to them for inadequate consideration, correct? And that too after the date of the order. So sir, it will be attached. Explanation 234 RTP. This you can cancel. Then, continuance of proceedings. Where a person dies, what will happen? His legal rep will come into the picture. He will pay the sum which the deceased would have been liable to pay if he had not died in the manner and the same content as the deceased. In case of any payable penalty under this act, a legal rep shall be liable only in case the penalty has been imposed before the death of the deceased person. After the death, if any penalty is imposed, you are not liable. A legal rep, you are not liable. Then, any proceedings for refund against recovery officer, okay, may be continued against the legal rep from the stage at which suit on the date of the death of the deceased. So, the person is dead, the person has died, so who will come in the picture? Legal rep. So, whatever is the, you want to apply, you want to take refund, you want to withdraw, whatever is the rights of the deceased person, same right is of the legal representative. Whatever the rights or obligation were of the deceased person, same obligation are of the legal representative. Any proceeding or disgorgement for refund for action for recovery before the recovery officer except proceeding for penalty may be initiated against the legal rep. Every legal rep shall be personally liable for any sum payable by him in his capacity as a legal rep. If while his liability for such sum remains undischarged, he creates a charges on or dispose of part of the assets. So if he try to sell the property, he becomes personally liable. It shall be liable to the extent to which the estate of the deceased person is capable to meet the liability. Whatever house is there, whatever property is there of the deceased person, to that extent you are liable. Legal rep you are liable, but only to the extent of the estate of the deceased person. To the extent of deceased person. Okay. If there is no estate, no liability. Law says you are liable, but liable to the extent of the estate. Always remember that. Okay. Person has died, the proceeding will start against legal rep. Okay. But the legal rep would be liable only to the extent of the estate of the deceased person. Understood? Cool. Read from appeal to SAT. Start reading. Done? Great. Now we are doing from here, the SEBI Act is over completely. From here we are going to do SEBI LODR, and right there important, very and very important. So from here we are going to do SEBI LODR. So listing obligation and disclosure requirements. So if you are a listed company, you have to comply with SEBI Act, plus you have to comply with SEBI, plus we have to comply plus we have to comply with listing obligation disclosure requirement 2015. Okay. Now, so firstly, this regulation is applicable to which securities? It is applicable to following designated securities on a recognized stock exchange. I hope you are clear with the word recognized stock exchange. Recognized stock exchange basically means BSE and NSE. There are only two recognized stock exchange. So specified securities listed where? So listed on main board, SME exchange or ITP, institutional trading platform. So specified securities listed on main board, SME exchange or ITP, institutional trading platform. Then main board like where Reliance, Tata is listed. Same SME exchange is a small medium platform. Institutional trading platform where mutual funds, bank, they all the large investors they trade. Okay. Non-convertible debt securities, non-convertible redeemable preference shares, perpetual debt instruments, perpetual non-cumulative preference shares. If this is listed, then IDR is listed. Securitized debt instruments under SARFAESI it is basic. Sorry, security receipts under SARFAESI it is. Securitized debt instrument basically you can say bonds. Then units issued by mutual fund, any other securities as may be specified by the board. So this is a one important question. SEBI LOD is applicable to whom? SEBI LOD is applicable which has to a company which has listed any of the following securities on a recognized stock exchange. Like specified securities you have listed on main board, SME or ITPs. Non-convertible debt securities, non-convertible preference shares, redeemable preference shares, perpetual debt instruments, perpetual non-convertible preference shares. Then in Indian depository receipt, then you have security receipts as per SARFAESI, then you have securitized debt instruments, units of mutual fund or any other as may be specified by a board. This is applicability. Cancel. Next one says board ka composition. So let's put numbers what you have to study. The first is applicability, right? Number one there. A lot of question would be there from this. Number two, composition of board. Sir, every company should have an optimum combination of both executive and non-executive directors. There should be optimum combination of executive and non-executive director with at least one woman director and not less than 50% of the board comprising of non-executive director. What does this mean? So there should be an ideal combination of executive and non-executive. So what does executive and non-executive means? People who come every day to the office, okay, who will be taking business decisions. This should be my product, we will sell to this customer, this is my manufacturing process. All those people who will be taking those working wala decisions are called as executive directors. Are called as what? Executive directors. People who will come like whenever they are called, like chartered accountants, lawyers, company secretaries. So they are professionals, okay, plus they are the directors in a company. Like I am a chartered accountant, I can be a director in a company, but I will not go every day to the company. I will go to my CEO office, right? I will not go every day. Whenever they are meeting, like board meeting is happening, I will go at that time. I will give them my expertise, my accountancy expertise, my law expertise. I will give them my audit expertise, okay, my analysis. So I am called as non-executive director. So it says there should be optimum combination of both executive, non-executive with at least 50% should be non-executive directors, and there should be one woman director. So woman director should be who? Executive, non-executive, anybody. Woman director can be anybody. So we will say there should be an optimum combination of both. There should be optimum combination of both executive plus non-executive plus one woman director, out of which 50% should be non-executive director. So for example, if there are 10 people, 10 में से 5 should be non-executive, balance 5 should be executive. If there are 11 people, 6 people should be non-executive, 5 can be executive. So always non-executive should be higher. Woman director, you can be anybody. You can be executive also, you can be non-executive. Woman director basically means a director who is a woman. She could be executive, she could be non-executive. Then next, where the chairman of the board is a non-executive director. Chairman of the board is a non-executive. Non-executive means outsider. Executive we say insider who comes every day. Non-executive means outsider. Then 1/3 of the board should comprise of independent director. So sir, if the chairman is non-executive, that means it's an outsider. So we require independent director as 1/3. That is basically 33.33% of the total board should be independent director. 1/3 of the total should be 1/3 of the total board should be independent director. So it depends upon the chairman. So if the chairman is executive, that means he is a person who comes every day. So he is influenced with the company. So we will require more independent director. It will be half, I think. Yeah. Then if the entity does not have a regular non-executive, so it does not have a regular non-executive, that means it is basically executive chairman, then at least half of the board should comprise of independent director. Half of the board, that is basically 50% should be independent director. 50% should be independent director. Very simple. Chairman is outsider, guys. Chairman is outsider. Chairman is outsider. So we require independent director less, 33.33%. Chairman is insider, that means he will have control over the company. So we look at more independent. Half should be independent director. Now, sir, where my chairman is non-executive, guys, where my chairman is non-executive, but he is connected to the company. Maybe he is a promoter of a listed entity, or he is related to any promoter, or a person occupying management position, or at the level of board, or one level below the board. Then at least half. Then at least half should be independent director. So my chairman is non-executive, but he is connected to the company in some way. My chairman, guys, is a non-executive, but he is connected to the company in some way. Then what do I require? Sir, my independent director should be half. Generally should be 1/3, but here we require half. One second. Yeah. Cancel this box. Not exam question. Provision related to independent directors are not applicable to Section 8 companies. That is, Section 8 companies, licensed company. Provision related to independent directors are not applicable to Section 8 companies. Sir, minimum age. Sir, minimum age of independent director is 21 years. Sir, maximum is a 75 years. So they have spoken basically about non-executive. The non-executive is independent director only. So minimum is 21, maximum is 75. But if you want more than 75 ka guy, like imagine you want a person who is above 80 years, around 80 years, okay, you want him to be your non-executive director. So you have to pass SR along with an explanatory statement. Why do you need him? So you have to pass an SR. You have to pass an SR along with an explanatory statement. Why do you need him? So minimum 21, maximum 70. If you want to go beyond 70, you have to pass SR along with a justification. Why do you need him? Why do you need him? Okay. Vacancy in the post of independent director should be filled within 3 months. So board is second. Yeah, board is only going on. Vacancy is also part of board only. Okay. Third, board meeting. There should be at least 4 board meetings in a year with maximum gap of 120 days. So between 2 meetings, the gap can be maximum 120 days. So gap should be there or gap can be there. So gap can be there. Minimum 4 board meetings in a year, max gap is 120 days. Minimum 4 board meetings in a year, max gap 120 days. Okay. Restriction on committee membership. Fourth, a person shall be a member of how many committees? 10 committees. A person can be a member in maximum 10 committees. He can be a chairman of 5 committees. He can be a chairman of 5 committees, not companies, committees. Okay. Across all companies in which he is a director. So like for example, there is a committee called as audit committee, nomination remuneration committee, stakeholder relationship committees. Okay. So you can be a member in 10 committees. So imagine in A Limited, I am a member in 3 committees. So my 3 is gone. Or in A I am in 1, B I am in 1, then C I am in 1. So that is 3. So either it is basically all inclusive. All inclusive is maximum 10 for the member. For the chairman it is 5. I can be a chairman in 5 committees across all the companies I am a director. I can be a member in 10 committees. Chairman in 5, member in 10. Chairman in 5, member in 10. Chairman in 5, member in 10. Then, for the purpose of considering the limit of committees on which a director can serve, all listed and unlisted public companies will be included. So you will include all listed and unlisted public companies, but what will you exclude? You will exclude private companies, foreign companies, section 8 companies will be excluded. So you have to exclude private companies, foreign companies, section 8 companies, and whenever you're counting about the committee ka limit, you have to count only two committees, that is audit committees and SRC, stakeholder relationship committees. That is other committee will not be included, that is membership of other committee will not be considered. Oh wow. So when you're counting about this limit, so firstly you talk about company, which company? Only public company and private company, sorry, listed company and unlisted public company, you will count that. In that also only two committees you have to see, audit committee and SRC. Audit committee and SRC. SRC का full form is stakeholder relationship committee. Audit committee and stakeholder relationship committee. Audit committee and stakeholder relationship committee. So first we talk about company, public company, and listed company and unlisted public company. Committee we will only consider audit committee and stakeholder relationship committees. So private company, foreign company, section 8 should be excluded. And other committee, whatever in the question they have given, you have to exclude. I can be a member in 10 committees. I can be a chairman in 5 committees. So in A, if I am a chairman in both the audit committee and SRC, so out of my 5, 2 are gone. In B also I am a chairman in 2, both the committees. So 2 is gone, only 1 is left then. Understood? So chairman in 5, member in 10. Point number 4, cancel, no question as such. Corporate governance with respect to subsidiary companies. So it says at least one independent director. Underline this, so this becomes your point number 5th. At least one independent director on the board of directors of listed entity shall be a director on the board of unlisted material subsidiary, whether incorporated in India or not. So my company ka one independent director should be a board of director on that unlisted material subsidiary. You call this as UMS. Unlisted material subsidiary. Subsidiary basically means more than 50% material. They would define what is material. Unlisted should mean not listed, whether incorporated in India or not. So my company ka board of director, so my company ka independent director will be sitting in that UMS unlisted material subsidiary as a director. Oh, material subsidiary means whose income or net worth exceeds 20% of the consolidated income or net worth. So that subsidiary is giving me more than 20%. So my company ka independent director will be sitting in that company ka board, provided that is my subsidiary and it is material and it is unlisted. UMS. This much is read. So the audit committee of the holding company shall also review the FS in the particular the investment made by subsidiary company. The minutes of the meeting of the subsidiary should be placed in the board meeting of the holding company. The management should try to bring the notice of board of holding company all any significant transactions arrangement entered into by UMS. So you have to inform to the your main holding company. Disclosures right there, RTP point number 6. Come to point number 7. Point number 6 RTP. Come to point number 7. Oh, this you can read. Disclosures when director is appointed or reappointed. In case of appointment of a new director or reappointment of the old director, what you have to give? You have to give brief resume of the director, his expertise, name of the companies in which the person holds the directorship and the membership of the committees, shareholding of the non-executive directors, either own or as a beneficiary. So details about the director, nature of his expertise, name of the companies in which he is a director, membership where he is a in which committee he is a member. We just did 5 May he can be a chairman and 10 May he can be a member, and shareholding of non-executive director. Then CEO, CFO certification. It says the CEO appointed under the Companies Act and the CFO of the company shall certify to the board that they have reviewed the financial statement and the cash flow. The certificate should be submitted to the board annually. Underline that, annually. When annual accounts are presented to the board, appointment of CFO shall be approved by audit committee before finalizing of the appointment of CFO by the management. So appointment of CFO shall be approved by audit committee. Then Annual report on corporate governance to the member. Just circle annual report. You have to give annual report of corporate governance to the member. So in the annual report, you will be writing that we have complied with this corporate governance, that's LODR ka regulations, and write the RTP. No concept. No concept. Clear. So there is no concept here. Basically, it's a report on corporate governance in the that will be part of your annual report. So annual report means there is a particular section that the company has complied with corporate governance. That is basically solely listing, obligation, disclosure requirement that we have complied with full LODR. So they have to give all these details. Audit committee ka details, remuneration committee ka details, stakeholder grievance committee ka details, general body meeting ka details, and other disclosures like related parties. So all these are disclosures. Basically, all disclosures you have to give. So you just read this part. Cool. Transparency, cancel. This also cut. Cancel. Cool. So you will read whatever we have marked till we have reached till I think point number 5. Whatever the content we have to study for LODR, we are marking it out because there could be a probable question on this. Okay. So read the entire LODR. Whatever 5 pointers we have marked. And whatever we have marked as read, you read that for as a first time and the last time. But when you are revising, you will not read it. Okay. Read. Done hai? Cool. So we have completed our SEBI LODR ka 20% part. 80% is pending. That 80% will be doing in the next class. Okay. I hope you have understood the SEBI Act. Now we are on to LODR. LODR has to be complied by every listed company which have listed or specified security. What we did in point number 1. We'll be marking pointers here because out of SEBI Act and LODR has more weightage because there are a lot of small concept numbers where ICA will be playing with us with regard to those numbers. Okay. We continue in the next class. Okay. Bye guys. Take care. Enjoy. Aim for rank or 70 plus, which was earlier. Bye guys. Take care. Hi guys, what's up? Welcome back to the class, and we were doing our SEBI. SEBI mein we have completed SEBI ka hack. We have started with LODR. LODR we have completed 20%. Okay. So now we have done 5 points of LODR. Please open the book. So we continue. We have done applicability. We have done about composition of board of directors. Number 3, we have done about board meeting. There has to be 4 board meetings a year. Max gap between 2 board meetings is 120 days. Gap can be there. Then restriction on committees membership. 5 committee may you can become a, 10 committee may you can become a member. 5 may you can become a chairman. Across all the listed companies and unlisted public companies, you have to only count a audit committee and a stakeholder relationship committee. Then one independent director of your board should be a director on UMS, unlisted material subsidiary. Till here we have done. Okay, now come to common points. Common obligation of listed entity. A listed entity shall appoint a company secretary as the compliance officer. So every listed company have a company secretary who is the basically compliance officer. It's so appointed shall be responsible for ensuring compliance with all the laws, basically coordination and reporting to the board, ensuring the correct procedures have been followed that would result in the correctness of information filed by the listed entity. So just mark compliance officer, company secretary, compliance officer, company secretary. Just mark that. Then the listed entity shall appoint a share transfer agent or manage the transfer facility in-house. Either you appoint an agent or you manage in-house. Generally 90% companies outsource it. Okay. Now this becomes your point number 6. At least one independent director on the board of the listed entity shall be a director on the board of UMS, unlisted material subsidiary. That means our independent director should be the director on the board of that UMS, unlisted material subsidiary. Subsidiary you become at more than 50%. Material you become when that subsidiary contributes more than 20% of the consolidated income or the net worth, and it has to be unlisted. So they have given the definition of material subsidiary. This is the first point. Then second, a listed entity shall not dispose of shares in material subsidiary in reduction of which where the value decreases less than 50% unless passing SR in the general meeting. Logical it is. If you are selling the share, my share was 52%, so that became my subsidiary. If I am selling 3%, it will become 49. I will lose the control of subsidiary. I can't sell the shares. If I want to sell the shares, I need to take the approval of my members via SR. Exception where the divestment is made by the court or tribunal as per IBC or such event is disclosed to the recognized stock exchange within 1 day of the resolution plan being approved. Okay. However, if that reduction, that selling of shares is given by whom? By the court or tribunal as per insolvency bankruptcy code, and that has been intimated to the recognized stock exchange within 1 day of the resolution plan approved, then you can sell without passing SR. So generally, if you are selling the shares where the shareholding reduces below 50%, then you require SR. But SR is not required when the plan is approved via insolvency bankruptcy code and the same has been intimated to recognized stock exchange within 1 day of the resolution plan approved. Okay. Next, selling, disposing and leasing of assets of more than 20% of the material subsidiary on an aggregate basis. Again I repeat, selling, disposing, leasing of assets amounting to more than 20% of the assets of the material subsidiary, sir, shall again require prior approval, shall require prior approval of SR, that is members ka approval. However, if it is approved by our court or tribunal under IBC and the event is disclosed to the recognized stock exchange within one day of the resolution plan being approved, then no approval is required. Generally require SR, but in this case you do not require SR. In this case you do not require SR. Okay, so this can be a question in the exam. Just remember there are 3 points here. Number 1, our company ka independent director should be the director on the board of UMS. Okay, subsidiary material becomes more than 20% consolidated net worth, unlisted is basically it is not listed. Number 2, if you are selling the assets, if you are selling the shareholding in that subsidiary, you require members ka approval via SR, but approval is not required if the scheme is approved via resolution plan under IBC. Next, selling, leasing, disposing of the assets amounting to more than 20% of the material subsidiary requires SR. However, approval is not required if the scheme is approved via court or tribunal under IBC and the event is disclosed to the recognized stock exchange within one day of the resolution plan being approved. Okay, then number 7, quarterly compliances. The listed entity shall file the recognized stock exchange on with recognized stock exchange on quarterly basis. Please mark this, within 21 days from the end of each quarter, a statement giving the number of investor complaints. So investor complaints has to be given quarterly within 21 days of the quarter. Opening, closing, dispose of, that's all. Opening, received during the quarter and dispose of during the quarter, and those remaining unresolved at the end of the quarter, that's closing. Opening, additions, closed, balance. So quarterly basis. Investor complaint quarterly basis 21 days, investor complaints 21 days quarterly basis. Then a listed entity shall submit on quarterly compliance report on corporate governance in the format as specified from board to time to the recognized stock exchange within 15 days from the close of quarter. Okay, corporate governance ka requirement, compliance with corporate governance in the format of the specified by SEBI, again it is quarterly within 15 days. Investor complaint 21 days, this is within 15 days. Shareholding pattern. Now, listed entity shall submit a statement showing holding of securities and shareholding pattern for each class of securities on a day prior to the listing of securities on the stock exchange, on quarterly basis within 21 days from the end of the each quarter, then within 10 days of any capital restructuring of the listed entity when there is a change exceeding 2% of the total paid up capital. So, when you are getting listed, one day prior you will inform to the SEBI, okay, to the exchange. Number 2, on quarterly basis within 21 days from the end of the quarter. Okay, if there is a change of more than 2% of the total paid up capital, then within 10 days of any capital restructuring, within 10 days. Then financial results. The listed entity shall submit quarterly and year to date standalone financial results to the stock exchange within 45 days of end of each quarter, other than the last quarter. Within 45 days of the end of the each quarter other than the last quarter, within 45 days of the end of each quarter other than last quarter. Statement of deviations, again it has to be submitted on quarterly basis. They came up with IPO, and they have used it for the some other purpose, so they have to include the deviations, if any, from the proceeds of the object stated in the offer document or expense statement, and they have to give category wise variations. So these are 5 disclosures. Which listed entity has to give. This can definitely be asked in the exam. Again we do. Okay, investor complaints quarterly within 21 days from the end of the quarter. Corporate governance compliance within 15 days from the end of the quarter. Shareholding pattern 1 day prior to the listing, then within 21 days of the quarter. And if there is a change of more than 2%, then it is within 10 days of the capital restructuring. Okay, financial result within 45 days of the end of the quarter except the last quarter. And quarterly deviations, statement of deviations and variations in IPO, use of IPO, FPO company, it is quarterly basis. Cool. Then financial results, prior intimation of the board meeting. So please circle board meeting. So if the board meeting is happening for approval of financial results, so you have to give 5 days in advance to the exchange. 5 days in advance. For other purpose, it is at least 2 working days, excluding the date of intimation, the date of meeting. Financial result, it is 5 days in advance. For other purpose, if you are having a board meeting, at least 2 days in advance, excluding the date of meeting and the date of intimation, excluding the date of intimation, the date of meeting, exclude that pure 5 days, exclude that pure 2 days. These are the purpose they have given. I am writing here RTP. Then listed entity shall give intimation to the stock exchange at least 11 working days, before any of the following proposal is placed before the board of directors. What are the proposals? Sir, any alteration in the form or nature of securities that are listed on the exchange or in the rights or privilege of the shareholders. So, you are changing the nature of securities or you are changing the rights or privilege of the shareholders. Any alteration in the date on which the interest or debenture bonds or the redemption shall be payable. So, if this is the purpose, then you have to intimate to the stock exchange at least 11 working days prior. Then, a listed entity shall give a notice requiring to the stock exchange of a record date specifying the purpose of record date for closure of books. 7 working days. Closure of books, 7 working days. Every time you will exclude the date of intimation, the date of the meeting. Here, shall recommend declare dividend or cash bonus at least 5 working days. So, for dividend it is 5 working days. Then, website. A listed entity shall update any change in the content of the website within 2 working days. Within 2 working days from the date of change in the content. So, this is prior intimation of board meeting, right? They are very important. So, for financial results, if you are having a board meeting, 5 days in advance. For this purpose, it is 2 days in advance. Okay. For if you are meeting for changing in the nature of the securities or the rights of the shareholders or change in the date where the interest or bonds ka interest is to be paid or redemption of preference shares is to be paid. Okay. It is 11 working days. Then closure of transfer of books, it's 7 working days. Dividend, it is 5 working days. Website may change, it has to be intimated to the within 2 working days. Within 2 working days from the date of such change. Everywhere it was prior. Website may you have made the change, then you will inform them within 2 working days. Then annual and yearly compliances, right? Here also important. Listed entity shall submit standalone financial results for the financial along with the audit report and form A for audit report with an unmodified, form B for audit report with the modified opinion within 60 days from the end of the financial year. So, financial results, see that was the board meeting you are having for approval of financial results. So, you are calling the board meeting, you need to intimate to the stock exchange 5 days before. Here you are submitting the results, to the exchange within 60 days from the end of the financial year. Annual report. Generally, it is 21 days only before the date of meeting. Sir, the listed entity shall submit to the stock exchange, publish on the website a copy of the annual report sent to the shareholders along with the notice of the annual general meeting not later than the day of commencement dispatched to its shareholder. That is 21 working days. In Companies Act you have studied at inter level. Okay. If there is a change in the annual report, it should be sent not later than 48 hours after the date of annual general meeting. If there is a change in the annual report, so annual report must have been changed at annual general meeting. So, then within 48 hours you have to intimate to the shareholders. Then, a listed entity shall send annual report to the holder of securities not less than 21 days before the AGM. I told you 21 days before. Then, role of compliance officer, right there, read. Not an exam question. These are the duties. Compliance officer. Who will be the compliance officer? Company secretary. Who will be the compliance officer? Company secretary. Correct. Corporate governance. The following reports are submitted to the stock exchange. Quarterly compliance report we just did within 15 days from the end of the quarter. Compliance report to be submitted within 6 months from the end of the financial report may be submitted along with the second quarter report and annual compliance report. So, quarterly compliance report, half yearly compliance report, annual compliance report. Okay, just read. . 21 days was the grievance quarterly compliance report within 15 working days from the close of the quarter. Corporate governance compliance is 15 days. So, that would be a repeated question. probable question in the exam, quarterly compliance report has to be submitted within 15 working days. Within 15 working days. Remember 15 working days, okay? Cool. So you will read till this. So quarterly compliance 7th. Right there, board meeting is 8th. Prior intimation of the board meeting is 8th. Annual yearly compliance is 9. 9 till here. So till now 9 points are there which you need to recall it again and again, okay? Read from common obligations of listed entity. Read. Hi guys, welcome back to the class. There was an error in that file, so it got recorded half only, and then it was not getting on. So we stopped the video there only, and then we continue. So I think we have completed till this corporate governance, and we have completed 9 points. I hope you remember all the 9 points. Okay, let's proceed further. Now we are doing types of committees under LODR obligations. Mark this as point number 10. Types of committees. The first we talk about audit committee. I hope you are very much clear with the composition of the board. There has to be an optimum combination of both executive and non-executive, where is more than 50%, sorry, minimum 50% should be non-executive and one woman director. Woman director could be executive also, could be non-executive also. If the chairman is non-executive, that means an outsider, one third of the total, that is 33.33% should be independent director. If he is half, I mean, if the chairman is executive, then half of the board should be independent director. I hope you remember that concept. Okay. Now, we do it from your audit committee. It says every listed company, because see, this chapter is applicable to listed company, common sense it is. So every listed company shall have a qualified independent audit committee which shall have 3 directors as members. So in audit committee, 3 people would be sitting. Two third of the members should be independent directors. Two-third of the total should be independent directors. Then all the members of the audit committee should be financially related, out of which one member should be expert, should be pro in either FR or AFM. At least one member should be having accounting or related financial management expertise. Accounting or financial management expertise. Again, we do 3 people would be sitting, out of which two-third, that is 66.67, should be independent directors. All members should be financially literate. One member should be having accounts and FMK expertise. The chairman of the audit committee shall be independent director, and he should be present at the AGM to answer shareholder ka query. So the chairman of the audit committee should be independent director, and he shall be present at the AGM to answer shareholder ka query. The CS shall act as a secretary to the committee. The CS shall act as a secretary to the committee. The CS shall act as a secretary to the committee. The CS shall act as a secretary to the committee. Then the company ka CS is a secretary to the audit committee. The audit committee shall invite finance director or the head of the finance function, head of internal audit, or the representative of stat auditor or any other executive to be present at the meeting of the committee. But is it mandatory? No. The audit committee can call either finance director or head of the finance function or internal audit ka some person or stat auditor ka some person. They can call them, but it is not mandatory. Sir, audit committee will meet how many times? 4 times in a year, and not more than 120 days should elapse between 2 meetings. So same concept as board meeting. Board meeting also was 120 days, 4 more meetings, and max gap is 120 days, same as board meeting. The quorum shall be 2 members or one third of the members of the audit committee, with whichever is higher, at least with at least with at least two independent director. So we'll say one third or two. We'll say like this: one third or two, whichever is higher, subject to two independent director. Subject to two independent director. One second. Huh? I was looking for some committee ka short I have made somewhere. So here it is, listed company code is applicable. Chairman has to be independent director. He should be present at the AGM. Members minimum minimum 2/3 should be independent. All members should be financially literate. One should be expert. Okay, minimum 4 more meetings. Max cap one is 120 days. Quorum 1/3, which is higher, subject to independent directors. Okay, it is there. Then nomination remuneration committee, NRC, nomination remuneration committee. So the committee shall comprise of how many directors? Sir, minimum 3 directors. All directors should be non-executive. All should be non-executive. At least 50% should be independent. At least 50% should be independent directors. Here, 2/3 should be independent. Na? 2/3 should be independent. In audit committee, 2/3 should be independent. Here it is 50% should be independent. The chairman of the NRC shall be independent director, same as audit committee. Provided that the chairman of the listed entity, whether executive or non-executive, may be appointed as a member of NRC but not chair such committee. Okay. The chairman of NRC should be independent director. The chairman of the NRC, whether executive or non-executive, may be appointed. The chairman of the company cannot be the chairman of the committee, but he can be the member of the committee. He can be member of the NRC, but he cannot be the chairman of the committee. The chairman of the company cannot be the chairman of this committee, but he can be the member of this committee. The quorum is 1/3 or 2, whichever is higher. 1/3 or 2, whichever is higher, subject to at least one independent director. At least one independent director, subject to at least one ID. Here it is 2 ID. There it is 1 ID. SRC. Oh, the chairman should be present at the AGM to answer shareholder queries. However, it shall be up to the chairperson who will answer the query. So, chairman should be present at the meeting. The chairman can say, I can't answer. Oh, Mr. Ram will answer. Mr. Sham will answer. It is upon the chairman to decide who will answer the queries. The NRC shall meet at least once in a year. They shall meet at least once in a year. SRC. SRC, the chairman of the SRC is formed to look up to the aspects of interest of not only the shareholders, debenture holders and other security holders का grievances. The chairman of the committee shall be non-executive director. The chairman of the committee shall be non-executive director. Okay, the board of directors shall decide other members of this committee. At least 3 directors should be there, 1 should be independent. So same as NRC, 3 directors, 1 should be independent director. The chairman of SRC shall be present at the AGM to answer the queries of security holders. The SRC shall meet at least once in a year. Only audit committee and board is 4, both the committees once in a year. RMC. The board shall constitute RMC. The majority of the RMC shall consist of members of the board of directors. The majority of the members of RMC shall consist of board of directors. The majority is basically board of directors. So others would be senior executives of the company. The chairman of the RMC shall be a member of the board, and other senior executive may be the members of the committee. So in RMC, majority would be board of directors and others would be senior executive, but the chairman has to be the board of director. Then the RMC shall meet at least once in a year. Cancel this 30. The RMC shall also meet at least once in a year. The chairman of the RMC shall be member of the board and other senior executive may be members of the committee. Same point, copy pasted. The board shall define the role and responsibility of RMC and may delegate monitoring and reviewing of the risk management plan to the committee and such other functions. The provision of RMC shall be applicable to top 500 listed entities on the basis of market cap at the last year. Last year का 31st March का top 500 listed को ही RMC is applicable. Everything is applicable to every listed companies. Only RMC is applicable to top 500 listed companies. Cool. Read these committees. All the 4 committees: audit committee, NRC, SRCs and RMC. 90% there would be a question on this. 90%. Okay? This is point number 10. Very important. Read. Done. Let me just check once. There has to be some update in risk management committee. We'll check once. Hmm. There's a change in RMC. Please make the change in RMC. The board shall constitute a risk management committee. They shall have minimum 3 members, with majority of them being board of directors, and at least one independent director. Minimum 3 members, with majority of them being members of the board. Right there, RMC shall have 3 members. Point number 2, the RMC shall have 3 members, at least one independent director. With at least one independent director. RMC shall meet at least, right there, twice in a year. RMC shall meet at least twice in a year. Max gap is 180 days. Max gap 180 days. Max gap 180 days. Okay. Then write there quorum for RMC meeting. Quorum for RMC meeting. 1/3 or 2, which is higher, at least one member of the board. 1/3 or 2, whichever is higher, at least one member of the board in attendance. 1/3 or 2, whichever is higher, subject to one member of board of directors. Quorum for RMC meeting is 1/3 or 2, which is higher, subject to one member of board. Copy this. Okay. It's applicable to top, write there 1000 listed entities, top 1000 listed entities, and a high value debt listed entity. They have not defined what is high value, just write high value debt listed entity. High value debt listed entity. And high value debt listed entity, and high value debt listed entity. Clear? So let's have a chart of this. This is a chart summary of all the committees. I would request you that you draw it somewhere. Okay, wherever you have space, I'll give you some time. Okay, SRES basically means superior right equity shares. SRES basically means superior right equity shares. In case of a company having superior right equity shares, all should be independent director. Here, two-thirds should be independent director, two-thirds should be independent director, two-thirds should be independent director. This is just a point for superior right equity shares. Superior right equity shares are basically given to startups. It is not there in the syllabus. Just understand, if the question says if the company has superior right equity shares, then all should be independent director. Here, two-thirds should be independent. Here, two-thirds should be independent. Here, two-thirds should be independent. Okay, let me just first make you understand the all the committee ka diagram is this. Okay. So audit committee, NRC, SRC, RMC. So first is audit committee, then NRC, then SRC, then RMC, the level. Okay. So it's applicable to all, applicable to all, applicable to all, applicable to top 1000 listed entity plus high value debt listed entity. Now, how many members would be there? Minimum 3, 3, 3, 3. Submit 3 it is, everywhere 3. Here, all should be non-executive director. Here, majority should be board of directors. Extra point. Here, two-thirds should be ID, two-thirds, at least 50 should be ID, 1 should be ID, and at least 1 should be ID here. Chairman should be ID, non-executive has to be member of board. 4 board meetings, 4 audit committee meetings, max have 120 days. Once a year, at least twice a year, and max have 180 days. Then quorum, one third or two, which is higher, subject to two independent director, one third or two, which is subject to one independent director, not mentioned, one third or two, which is subject to one board of directors. Additional points, all members should be financially literate, out of which one should be member of financial management expertise. Chairman of the company may be appointed as a member but not chairman of NRC. This committee looks into complaints of various investors, and your senior executive may be a member. Other members would be senior executive employees of the company. In case of a company having superior equity shares, here generally it is two-thirds should be ID. Here it's all should be ID. Here 50% should be ID. Here two-thirds should be ID. One ID, two-third ID. One ID, two-third ID. Okay, the question will specifically mention what about superior right equity shares. Okay, copy this somewhere. Where will you copy? Let's hunt for some space. Either you can take a post-it or some page and post it here only, the summary of committees. Okay, because as such there is no space somewhere. There will be a question on summary of committee. Here it will not come. So you need to stick a page here. Okay, 90% there will be a question on this. So it's 23 minutes right now, giving you 10 minutes time. So I think in 10 minutes you'll be able to complete summary of all the committees. Please copy. Last point is top 1000. LE means listed entity. High value debt listed entity. Please copy this diagram. It's important. Copy. Done है? Finish guys. Complete it. Now, let's move on to ICDR regulations. Now, it says SEBI ICDR, that's issue of, we have done listing obligation disclosure requirement. This is ICDR, issue of capital and disclosure requirement, ICDR 2018, issue of capital and disclosure requirement, we call this as ICDR. Okay. Cancel this. Now, so whenever a company in India wants to raise money from public, they have to issue shares. So issuing shares are basically via two modes. One is IPO, other one is FPO. So IPO is basically initial public offer. Initial public offer. FPO is basically further public offer. Further public offer. Further public offer basically means, see, when you come for the first time, like Swiggy, Zomato came, Nike IPO came. So that is basically first time when somebody is coming up with an issue, it's called as IPO. Subsequent issues are called as what? FPO, further public offer. Subsequent issues are called as FPO, further public offer. So when an issue or offer of shares or convertible securities is made to investors for becoming the part of the shareholders family of the issuer basically means the company. Okay, it is called as public issue. It is called as what? Public issue. It is called as public issue. Public issue could be a IPO, could be a FPO. Sir, IPO basically means what? IPO basically means what? IPO is basically for the first time when you come up with the public issue. It means an offer of specified securities by an unlisted issuer to the public for subscription and includes an offer for sale for specified security to the public by any existing holders of the company. That issue shall be made to public and not to the existing shareholders of the unlisted issuer company. So if it's an unlisted company, it's coming with the first time, they are offering securities to the public, it is called as IPO, FPO. Here they will use the word listed company because you're already listed. So they are using the word what? Listed. So it means an offer of specified security by a listed issuer to the public for subscription and includes an offer for sale of specified securities to the public by way of existing holders of specified securities in a listed issuer. So in a listed company, when you offer subsequent issue, it is called as FPO. FPO could be right issue. Right issue basically means we are offering the shares to existing shareholders. We are offering to the existing shareholders. It is called as right issue. Composite issue. It basically means both. Whether shares or convertible security by listed issuer on public come rights basis, like that means you are offering to existing also to the public also. It is called as what? Composite issue. It is called as composite issue. Bonus issue. Bonus issues are giving to existing shareholders. Here the company will not get any money. It is for free. Just the number of shares gets increased. Number of shares gets increased. Private placement. So private placement basically means when you are offering the shares to particular group of people. So right now in Companies Act it is 50, in the rules it is 200. So right now you follow 200. So you are offering it to maximum 200 persons in aggregate in a financial year. It is neither a right issue nor a public issue. It is called as a private placement. Here, like for example, I am offering it to this 200 people, A, B, C, D, E, F, G. I am offering to this 200 people. Only this 200 people will apply. So I know whom I am offering. I know who will apply. That is called as private placement. Okay. Now, private placement can be by offer. Private placement can be done by both public company also and by private company also. But in our syllabus, we are talking about only public company because we talk about listed companies. So it's a public company only. Okay. Now, private placement of shares or convertible securities by listed issuer can be of two types. One is preferential issue, other one is QIP. One is preferential issue, one other one is QIP. So, preferential issue is basically given to particular group, like for example, bank or a mutual fund. It says it is issued by a listed issuer to any select person or group of person on a private placement basis as per so and so regulation and includes and does not include an offer specified securities made through ESOP. So it will not include ESOP or sweat equity shares or deposit received in a country outside India or foreign securities. It means you are offering it to a particular person. It means like imagine I am offering it to HDFC Bank or maybe HDFC mutual fund. I'm offering it to one particular category. That's called as preferential. So over others, I am choosing one person. That is called as preferential issue. QIP. So basically, promoter will sell the securities. It means issue of eligible security by a listed issuer to a QIP, qualified institution buys on a private placement, includes an offer of sale of specified security by the promoters or promoter group on a private placement basis in terms of these regulations. So when the shares are sold by promoter or promoter group, like families, like Mukesh Ambani ka family, Neeta Ambani, okay, Isha Ambani, all these people are when they are selling the shares, it is called as QIP, qualified institutional placement, QIP, qualified institutional placement, okay. Then other relevant definitions. Book building. So book building is basically means when you are creating a demand of your securities. So in order process undertaken to elicit the demand and to assess the price for the determination of the quantum or value or coupon of the specified securities or IDR as the case may be. So book building is like basically how much you will buy at what price, how much you will buy at what price, how much shares you will buy at what price. So you are trying to create a demand to understand the quantum and the price. The quantum and the price. Convertible debt instrument. Convertible debt instrument basically means any bond or any bond, any loan document, any debenture which will be converted into equity at a later stage, which will be converted into equity shares of the issuer at a later date at without the option of the holder of the instrument, whether constituting a charge or not. Okay. Convertible security basically means which is converted into equity shares, which is converted into equity shares called convertible security. These are just the definition for our knowledge, not so important. Designated stock exchange where the securities are listed, that's called designated stock exchange, listed or it's about to get listed. Green shoe options, it means on option of allotting equity shares in excess of the equity shares offered in public issue as a post listing price stabilization mechanism. So green shoe option, imagine to stabilize the price we are offering more shares to some people, it is called as green shoe option. It will come at a later stage. It can be understood in the layman language as an over allotment options. So you have applied for 100, we are offering 110. So that the price is maintained. So that is called as over allotment. It is a price stabilization mechanism which is used in case of listing of IPO or of FPO within first 30 days from the day of listing. The intent is to provide support in case price falls below issue price. It is called as green shoe option. So we are giving you more shares even though you have not asked, we are giving you more shares. Offer document, it basically means what? Red herring prospectus, shell prospectus or any document offer which invites money from the public to subscribe for the shares in the company. So these are some definitions. Applicability of the regulations. It is applicable to whatever content we have just did. The same words will be used here. It's applicable to IPO by an unlisted issuer. Obviously, we are unlisted company. Once your issue comes, then only you will become listed, right? So IPO is offered always by an unlisted issuer. Right issue, who offers right issue? By a listed issuer with aggregate value of issue 50 crores or more. It's called right issue. FPO by a listed issuer, preferential issue by a listed issuer, QIP by a listed issuer, IPO by IDR, right issue of IDRs, IPO by small and medium enterprise called SME, then a listing on the innovators grid platform and a bonus issue by a listed issuer. Okay, just always remember IPO by an unlisted issuer. In case of right issue of right issue less than 50 crore rupees, the issuer shall prepare the letter of offer as per the requirements specified in this regulation and file the same with the board for information dissemination on the board website. Because generally this ICDR regulation is applicable only if you are coming up with right issue where the value of the right issue is minimum 50 crores, minimum 50 crores, minimum 50 crores. Then only these regulations are there. If it is less than 50 crores, just you inform to the board. You inform to the board. Board basically means SEBI. This regulation shall not apply to the securities under clause B, D, E of sub-regulation 1 of regulation 9 of SEBI takeover regulation. Okay, this is just one of the point. Just remember right issue 50 crores, then only ICDR is applicable. Less than 50 crores, you just need to intimate to the SEBI. You need to intimate to the SEBI. Cool. So this much you will read and come now. Read these 3 pages. Definition. These are basic definitions. Then we'll get into the regulations. Read. And cool. Now, let's do IPO on the main board. Okay, so main board is basically BSE, NSE, where you buy and sell the shares. Okay, there's one more platform called as SME. So there are certain shares which are listed on SME. There are 90% shares are listed on the main board, like Reliance, TCS, Infosys, HUL, Adani, where whatever share you buy, your parents are buying and selling, it is listed on the main board. So what are the requirement? So please take a pen and pencil, because wherever there is a number or days, we need to mark that. That would be a probable question in the exam. An issuer making an IPO of specified security shall satisfy the condition of this chapter as on the date of filing of the draft offer document with the SEBI, and also on the date of filing of offer document with ROC. So you have to comply with all the requirements. What are the requirements? Sir, entities which are not eligible to make IPO. Entities which are not eligible to make IPO. First one. If the issuer any of its promoters or promoter group or directors or selling shareholders are debarred from accessing capital market by the board, like Vijay Mallya, Nirav Modi, Subrata Roy, all those people are debarred. So there's people, a company cannot come up with IPO. If any of the promoters or the issuer is a promoter or director of any other company which is debarred from accessing capital market by the board, I am a director, example, I am a director in, let us assume, UB Group, or maybe like Nirav Modi ka company, and Nirav Modi ka company is barred. I am also director in AB Limited. AB Limited want to come up with IPO, not allowed. Why? Because AB is a common director there. That company is barred, so this company is also barred. If issuer or any of the promoters is a willful defaulter or a fraudulent borrower, Vijay Mallya, Nirav Modi. Okay, if any of the promoter is a fugitive economic offender, purposefully they are offending, they are committing crime. Which crime? Economic crime. So they are not allowed. They are prohibited. However, the restriction A and B shall not apply to the person or entities mentioned who were debarred in the past and the period of debarment is already over. Logical it is. You were debarred and the period, like 5 years you are debarred, 10 years you are debarred, and 10 years are over. Now you can come up with the IPO. A issuer shall not be eligible to make IPO if there are any outstanding convertible securities or any other right which would entitle any person with any option to receive equity shares. So if your any convertible bonds are there or any issue is pending, you need to convert them into equity, then only you can come up with IPO. Exception, the regulation sub 2, this regulation shall not apply to outstanding options granted to employees. If you have given to employees, it is outstanding because there is a period, 3 years ka vesting period is that, then the employee will exercise. Then even if still it is outstanding, you can come up with the IPO. Fully paid up outstanding convertible securities, such securities which are required to be converted on or before the date of filing of the red herring prospectus, or in case of fixed issue price, or as the case may be. So two case may this rule is not applicable. Generally it says if it is outstanding, you can't, if there is any outstanding convertible securities, you cannot come up with IPO. But to exception, if your ESOPs are outstanding or fully paid up outstanding convertible securities are there, still you can come up with IPO. Eligibility requirement. An issuer shall be eligible to make IPO only if, please underline that, if they have net tangible asset of at least 3 crore rupees. Net tangible assets of 3 crore rupees calculated on a restated and consolidated basis in the past 3 years of 12 months each, of which not more than 50% are held in monetary asset. Not more than, that means maximum is in monetary assets, investment basically. If more than 50% of the net tangible assets are in monetary asset, the issuer has utilized or made firm commitment to utilize such excess monetary assets in its business or project. Okay, if you are cash rich, monetary assets, if you are cash rich, why do you need to go for IPO? Because ideally IPO say what you are doing, you are offering shares and taking money. You already have money. Why do you need more money? So if you have more than 50%, you have made a commitment that I will use in my business or project. Provided the limit of 50% monetary assets shall not be applicable in case IPO is made entirely through an offer for sale. Offer for sale is basically OFS, which is given by like a substantial shareholder is selling his shares. Imagine I am a big investor in, let us assume, Adani Group. I am selling my shares. So I can't sell it directly, because if I sell directly, what will happen? I am a substantial shareholder, that's 10% holding. If I sell directly, the price will fall down, right? So to control that price, SEBI says, AB, you want to sell the share, you inform to the company. So company will offer the shares to public. Your shares only will go. So company is not coming up with IPO. They are selling from your demat. It will go to other people ka demat. That concept is called as OFS. In case of OFS, that 50% ka limit is not applicable. That 50% ka limit is not applicable. In case of OFS, that 50% ka limit is not applicable. Understood? Then it has an average operating profit. Average operating, whenever we say average, it is always have to be 3 years. Operating profit of at least 15 crore rupees. At least 15 crore rupees calculated on a restated and consolidated basis during the preceding 3 years. With each with operating profit in each of these three preceding, there has to be operating profit. Firstly, there has to be profit every time. Plus the average profit should be 15 crore rupees. So net tangible assets of 3 crores plus operating profit of 15 crore rupees, and there has to be profit every year. There has to be profit every year. Then net worth of at least 1 crore rupees in each of the three preceding financial years, calculated on restated and consolidated basis. If it has changed its name within last 1 year, at least 50% of the revenue, should be, has been earned by it from the activity earned by its new name. If you have changed the name, in case if you have changed the name, the 50% of the revenue should be out of the new name, because of the new name. So there are 4 conditions. Let's quickly recall. Net tangible assets of 3 crore rupees every time you say 3 years, okay, and 50% maximum should be in monetary assets, okay. Then 50%, if it is more than 50%, you are agreeing to spend it on your projects or business, and the 50% condition is not applicable in case of OFS. Average operating profit should be 15 crores. There has to be profit every year. Third, net worth should be minimum 1 crore rupees. Net worth should be minimum 1 crore rupees. And if you have changed the name, 50% of the revenue should be from the from the new name, okay. Exception to the above regulation. An issuer not satisfying the conditions stipulated in sub-regulation 1 shall be eligible to make IPO only if it fulfills the following condition. In case if you are not following those conditions, you can do it via if the issue is made by book building process and the issuer undertakes to allot at least 75% of the net offer to qualified institutional buyers and refund the full subscription if it fails to do so. Okay, if you don't want to fulfill condition 1, regulation 1, you can go via book building. 75% would be offered to QIBs, qualified institutional buyers like bankers, mutual fund people, or NBFCs, all those people. And in case if you do not meet that, you will refund it. Then, if the issuer has superior right equity shares, what are the conditions? The issuer shall be in the use of technology. Just read those condition: information technology, intellectual property, data analytics, all those new things. The net worth of the superior right shareholders as defined by registered value shall not be more than 1000 crores. 1000 crores. If are issued only to the promoters or founders who hold an executive position in the issuer company. The issue of superior equity shares had been authorized by a special resolution passed at the general meeting. Okay. The size, this are the details of the resolutions. So superior right shares have voting rights in the ratio of minimum 2:1 up to maximum 10:1 compared to the ordinary shares. So the promoter will have double voting rights. To which one up to 10:1, up to 10:1, 10:1. That means your one vote, I will have 10 votes. That is superior right equity shares. These are given to startups. Okay. An issuer shall have only one class of superior right equity shares. It shall be equivalent to ordinary shares in regards or in all respect except voting rights. They will have only superior voting rights. Normal people 1 vote, I will have 2 votes. Normal people 1 vote, I will have 3 votes. Like this, 10 votes I can have. Superior right equity shares. These are given to promoters and only in startup companies. So these are the basic conditions for when the company is issuing superior right equity shares. Okay. Now, do one thing. You read whatever condition we have done till now. You read these conditions till here before doing general conditions. Okay. Main conditions, remember, that can come in the MCQs. Okay. Read this much. I hope you have completed. So I hope you have understood the LODR का complete regulations. I hope you have written that summary. It's very important. There will be a question on that for sure. ICA का whatever important points are there, we are marking it out. Rest those are conditions that's only read when there was a descriptive paper. At that time it was important. Not as such when it's an MCQ based paper. MCQ based paper only the conditions are important and the limits and the days and the percentage wherever it is given. We are marking that. Okay, cool. Chalo. Bye guys, take care, enjoy and aim for rank or 70 plus, whichever is earlier. We continue in the next class. Bye guys, take care. Hi guys, what's up? Welcome back to the class, and we were doing our ICDR regulations. I mean the SEBI chapter in SEBI. We have completed SEBI Act, we have completed LODR ka regulations. Now we are doing ICDR ke regulations. Okay, wherein we have done the basics of ICDR. In ICDR we were on IPO. In IPO we have done the basic conditions. Now we are on the general conditions. Okay, so let's quickly mark whatever the pointers we need to remember for the exam. So regulation number 7. So it has made an application. An issuer making an IPO shall ensure that it has made an application to one or more stock exchange. In India, recognized are only two, but there are many stock exchanges like Ahmedabad, Rajkot, Chandigarh, Tamil Nadu. We call it Madras Stock Exchange. But recognized are only two, that's BSE and NSE. This is done with an intent to seek an in-principle approval for listing of its specified securities. So you have to apply to the stock exchanges for the approval. Enter into an agreement with the depository for demat of the firms. In India, there are two main depositories, NSDL and CDSL. So you get into an agreement with those, NSDL and CDSL. Acha. All the securities held by the promoters are always should be in demat form. It should be in demat, that is electronic form. All existing partly paid up shares either have been made converted into fully paid up or have been forfeited. Either you cancel or you convert them into fully paid up shares. Then it has made firm arrangements of finance to verifiable means towards 74% of the stated means of finance for a specified project. 75% of the stated means of the finance for a specified project to be funded from the issue proceeds. So whatever money you will get, you will use 75% towards one project, like for example product expansion, building expansions, technology, innovations, hiring of people. Okay, so you have given the utilization of funds. Okay, the amount for general purpose. It says, as mentioned, the object of the issue in the draft, it should not exceed 25% or being raised by the issuer. So 75% is for the specific purpose, 25% is for the general purpose. General purpose basically general company purpose, paying rent, some paying some loan, some general purpose basically, general corporate purpose for day-to-day working of a company. Then from where an issuer till year, write their RTP. Not an exam content to be remembered. Where an issuer till complied with. So out of 100 rupees you have received, 75 would be for specific purpose, 25 would be for general purpose. That's maximum percentages. Okay. Then ceiling on the amount raised by the issuer, ceiling on the limit. Okay, the amount for general purpose and such other objects where the issuer company has not identified the acquisition as or investment target as not as mentioned, the objects of the issue, offer document and the offer document shall not exceed 35% of the amount being raised by the issuer. Now, the amount for general corporate purpose and such objects where the issuer company has not identified acquisition or investment target. So, where they have not identified acquisition, that they are acquiring a company or they are making some investment, it should not exceed 35%. It should not exceed 35% of the amount being raised by the issuer. Out of 135, you can use it for this too. Generally, for general purpose, it is 25. But if you have not identified some investment also, it is cumulatively 35. 25 plus 10. Oh, the same point what I said. The amount raised for object where the issuer company has not identified acquisition investment as mentioned, the objects of the issue in the draft offer should not exceed 25% of the amount being raised by the issuer, which I said. So for general corporate purpose is 25 only. Okay, cumulatively is 35. Then only for fully paid up shares may be offered for sale to public which have been held by sellers for a period of at least 1 year prior to the filing of draft offer document. So whoever is holding the shares, so obviously people would be holding, promoters would be holding, and they will be selling the shares to the public. Then public will give the money. So this people, the seller should have hold the share for at least 1 year prior to the filing of DRHP for the draft offer document. Then, in case of equity shares received on conversion or exchange of fully paid up compulsory convertible securities like including depository receipts or maybe some preference shares or maybe debentures, then the holding period of such convertible securities including deposit receipt as well as the resultant equity share together shall be considered. In case if it is converted, so whatever you are holding in the old form plus the new equity share, whatever is the period, cumulatively will be counted. Generally you should hold for at least 1 year, but if it is converted like from debentures to equity, it is converted, from deposit receipt it is converted to equity, so together the period will be counted. And the 1 year should be required to be complied with at the time of filing of draft of offer document, at the time of draft of offer document. Okay, so 1 year you have to check. Then can you see explanation? Cancel this. No. It says when the requirement of holding equity shares for a period of 1 year shall not apply. Generally, it says the seller, I mean the company, the issuer company, promoters would be holding the shares for at least 1 year. Okay. If it is converted from any other security to equity shares, the together ka period would be counted, combined period would be counted for 1 year. Now we are studying this 1 year ka period will not be applicable where? Okay, some situations are there. In case of an offer of sale of government company or a statutory authority or a corporation or any special purpose vehicle which is set up or controlled by any one of them which is engaged in infrastructure sector. Okay, if it's a government company or a statutory authority or a corporation held in infrastructure sector, then if the shares are offered for sale were acquired pursuant to any scheme approved by the High Court or a tribunal or by CG under section, that's amalgamation chapter 230 to 34 as applicable, at that time this period of 1 year will not be applicable. If the equity shares were offered for sale were issued under a bonus issue on the securities held for a period of at least 1 year prior to the filing of draft of offer document with the board and further subject to the following conditions. The specific securities are issued out of free reserves and securities premium, and equity shares are not being utilized by a revaluation reserved. So in this situation, the period of 1 year will not apply. Number one, government company, government corporation, statutory authority are issuing the shares. Number two, the shares are were issued by a scheme of a high court or a tribunal or a central government under amalgamation chapters, section 232 to 34, or whether shares which are getting sold are bonus shares, and the bonus shares were offered out of securities premium and not out of reval reserve. Then the period of 1 year will not be applicable. Then point number 6, additional condition, write their RTP. Write their RTP, additional conditions. Cool. So you will read, then we'll do debt, convertible debt instruments and warrant wala point. So whatever we have studied right now, general conditions, regulation number 7, just go through once all the conditions. Okay, 75% should be used for specific purpose, 25% should be used for general purpose. If you have not invested, I mean if you do not have an idea to invest, it is basically 35, 35 ka breakup is 25 plus 10. Okay, read. Done? Next is issue of convertible debt instruments and warrants. Issue of convertible debt instruments and warrant. Now, when a company has convertible debt instruments and warrant, now when I say convertible, it is obviously converted into equity shares. Converted into equity shares. So, an issuer shall be eligible to make an IPO of initial public offer of convertible debt instruments even without making a prior public issue of its equity shares and listing thereof, provided they should have not defaulted towards any interest, repayment of principal amount in respect of the debt instruments issued by to the public for a period of more than 6 months. So, maximum default can be for 6 months, then only you can come up with IPO. So, if there is a convertible debt instrument, it's basically a bond, okay, or maybe debenture, where the company is supposed to pay some interest and you have not paid and 6 months have passed, then you can't come up with IPO. Okay. What are the additional requirements? So again, it's only read. What are the additional requirements? So they have obtained credit rating from at least one credit rating agency like ICRA, CRISIL. Okay. They have appointed one debenture trustees as per the SEBI regulations. They have created DRR, and if the issuer proposes to create a charge, the charge must have covered the amount of principal amount along. It should be free from any encumbrances. Whether security is created in favor of any existing lender, so you have taken the consent of that existing lender also. Then the issuer shall redeem convertible debt instrument in terms of the offer document. So basically it's normal point, not an exam question. So if there's a convertible debt instrument, these are the certain additional conditions. Now if we talk about the MCQs, see, very rare some question would be there on this concept. Okay, very rare. Then conversion of optionally convertible debt instruments into equity shares. Right there, no content here. RTP, point number 3. Regulation number 11, RTP. Regulation number 12, RTP. See, we are marking only those content where there can be a probable question in the exam. Come to issue of warrants. An issuer shall be eligible to issue warrants in an IPO. So in an IPO you are issuing warrants. The tenure of such warrants should not exceed 18 months. That's right there, maximum 18 months. So when you're coming up with IPO, you can issue warrants. Basically we issue this to promoters, okay, and promoter group. So we can issue it for 18 months. A specified security may have one or more warrants attached to it. The price for the formula of determining the existing price, exercise price of the warrant shall be determined upfront and disclosed in the offer document, and at least 25% of the consideration amount shall be received upfront. In case of exercise price of warrant is based on a formula, 25% based on the cap price of the price band determined for the linked equity shares shall be received upfront. So whatever price you have decided, like if you are issuing to promoters, okay, my equity shares are 1000 rupees. So warrant I will decide 75, maybe like 600 rupees. So 600 ka 25% should be received today. Balance 75% when you exercise that warrant, that time you have to pay. So price we have decided today only, and that price ka 25% we should receive it today. The company should receive it today. In case a warrant holder does not exercise the option to take equity shares against any of the warrants held by the warrant holder within 3 months from the date of payment of consideration, such concession made in respect of such warrant shall be forfeited by the issuer. So from the date of the payment of consideration, if you are not taking it within 3 months, so that 3 months, that payment whatever you have made, after 3 months that will be forfeited. So you have 3 months to make the full payment. If you have not made that, it will be forfeited. So write there important here, issue of warrants. Then promoters contribution. The promoters of the issuer shall hold at least 20% of the post issue capital. So 1 lakh was my existing, imagine 1 lakh 50 is my new capital, that is my post issue capital. So 50,000 we have issued share. So 50,000 ka 1 lakh 50,000 ka at least 20% should be held by the promoters. In case the post issue shareholding of the promoter is less than 20%, then AIF, foreign capital investor, scheduled commercial banks, PF5, insurance companies may contribute to meet the shortfall in minimum contribution as specified for promoter, that is for 20%, subject to a maximum of 10% of the issue capital without being identified as a promoter. So generally it should be 20%, minimum 20% of post issue capital should be held by the promoters, minimum. Okay, generally it is more only, but we are checking the minimum requirement. In case it is less than 20%, imagine it is 18%, so 2% is shortfall. That 2% can be given by either the foreign venture capital or a scheduled commercial bank or an alternative investment fund or any financial institutions or any insurance company, but they will not be called as promoters. They are making their own contribution. Okay, imagine they have only 9%, promoters only have 9%. So these people will come to contribute. These people can't contribute because maximum contribution by these people can be only 10%. So basic 10% should be of the promoters only. Then the promoter shall contribute 20% as stipulated in regulation 1 as the case may be, either by way of equity shares, including superior right equity shares, if any by way of subscription to convertible securities. By any form you have to hold 20%. Okay. If the price of equity shares allotted pursuant to conversion is not predetermined and not disclosed, the promoter shall contribute only by way of subscription to convertible securities being issued in IPO and shall undertake to subscribe to equity share pursuant to conversion of such equity shares. Uh, Basically it should be via equity shares. Okay, but if nothing is mentioned, they have to take the shares via convertible securities. Okay, and they will give a commitment, they will give a consent that post issue they will convert the securities into equity shares. In case of issue of convertible securities which are convertible or exchangeable on different dates, the contribution shall not be a price lower than the weighted average price. Then you will take the formula weighted average price. Then point number C, point number 3, 4, write the RTP. C, 3, 4. So right now what we got here is minimum contribution of the promoter should be 20%. Okay, but the bank, in case of a shortfall, the bank, the financial institution, the insurance company can contribute without being called as a promoter. They will not be called as a promoter. Okay, but their contribution can be maximum 10% of the post issue capital. Always have to check post issue capital. Where the minimum promoter's contribution is more than 100 crore rupees and IPO is for partly paid shares, then the promoter shall bring at least 100 crore rupees, 100 crore before the date of opening of the issue, and remaining amount may be brought on a pro rata basis before the calls are made to the public. So if you're coming up with a minimum contribution is more than 100 crore rupees, promoter's contribution, okay, is in amount terms it is more than 100 crore rupees and in the shares are partly paid up. So before the date of the offer, boss promoter you need to deposit 100 crore rupees, balance you can do it after also. So this is amount calculation, not so important. Cancel this. Read promoter's contribution. Read promoter's contribution. Then we do the locking wala part. Read promoter's contribution. Mark and whatever I have marked. Okay. Read. Then lock-in period. The specified securities held by promoter shall not be transferred. Following securities shall not be transferable. For how many period? Sir, minimum promoters contribution including contribution made by AIF, that's 20% dollar concept, shall be locked in for 18 months from the date of the allotment in IPO. It shall be locked in for 18 months. So promoters contribution including that contribution made by that insurance companies, AIFs, all those people, it can't be transferred for 18 months. Then in case of majority of the issue proceeds excluding the portion of offer for sale, that is proposed to be utilized for capital expenditure, then the lock-in period shall be 3 years from the date of allotment in the IPO. If the purpose of the IPO was capital expenditure, then the lock-in period shall be 3 years. Generally it is 18 months, but if it is capital expenditure, then it is 3 years. Promoters holding in excess of minimum promoters contribution shall be locked in for a period of 6 months from the date of allotment in the IPO. So if it is more than 20% of post-issue capital you want to sell, so that 20% it is locked in for 18 months. Okay, if it is more than that 20%, imagine 27%, that 7% is locked in for 6 months. However, it is for capital expenditure, then it shall be 1 year. If the proceeds are for capex, it is for 1 year. So generally it is 18 months and 3 years for capex. Okay, if it is whatever is more than 20%, it is basically 6 months and capex is 1 year. 6 months and capex is 1 year. Please mark that. The superior right equity share shall be under lock-in until the conversion into equity shares having voting rights as same as that of ordinary shares, or shall be logged in for a period specified in above regulation, whichever is later. Okay, it will be linked to your ordinary shares only, or the period mentioned above, whichever is later. Now, lock-in for specified securities held by persons other than promoters, like investors, like people who invest in pre-IPOs. Okay, I'm not talking about the promoters, I'm talking about the pre-IPO investors. There, it says it will be locked in for 6 months. It will be locked in for 6 months from the date of allotment in the IPO. Oops. Babu, please come. Yeah. Now, nothing in this regulation shall apply to equity shares allotted to employees. It's logical. Equity shares allotted to employee under ESOP. Though this regulation will not be applicable, that means lock-in card not be applicable. Equity shares held by ESOP trust transferred to the employee by an employee stock option trust. So employee stock option trust transferring it to employees under ESOP scheme not applicable. Equity shares held by venture capital fund, alternative investment fund of category 1 or category 2 of a foreign capital investor, there should be lock-in only for 6 months from the date of purchase. Cancel below. Come to point number 3. Lock-in of specified securities lend to stabilizing agent under the green shoe option. Okay, to stabilize the price. So when we have given securities to stabilize the price, the lock-in provision shall not apply with respect to specified securities lent to stabilizing agent for the purpose of green shoe option. That is basically to manage the price like just immediately after when the shares get listed. Okay, during the period starting from the date of lending and ending on the date when they are returned to the lender in terms of regulation 5 or 6 of sub regulation 57. Okay, the specified security shall be locked in for the remaining period from the date on which they are returned to the lender. So generally, in case of green shoe option, the lock-in period is not applicable. Then, if the specified security which are locked in are partly paid up shares, and the amount called up on such specified securities is less than the amount called up at the time of the public issue, it shall be locked in only for 3 years. Lock in for 3 years. The certificate of specified security which are lock-in shall contain the inscription non-transferable, which is in lock-in you have to write there non-transferable. Okay, pledge of locked-in securities. Specified securities except superior right equity shares held by promoters and locked in may be pledged as collateral as a security for loan. So you can give as a collateral towards the loan. cancel below ka part. Those are condition for the loan. It will not come in the exam. Then transferability of locked in securities. So it says the specified securities except superior equity shares can be transferred from to another promoter or any person of the promoter group or a new promoter. The promoters ka lock-in will see if there's 18 months ka lock-in. Okay, if you want to transfer, you can transfer to another promoter or another promoter group, any person of any promoter group. The specified securities by person other than promoters, that is normal people. Okay, the 6 months ka lock-in is there. If you want to transfer, it says it may transfer to any other person holding specified securities which are logged in along with the securities purport to be transferred. So if I am already an existing shareholder and you want to transfer your securities, you can transfer to me, not to another person, even though the shares are in lock-in. So these are basically within that lock-in period who can transfer. Promoter, you can transfer to another new promoter or a person of a promoter group. Normal people you want to transfer, you can transfer to another shareholder of the company. Provide the lock-in for such specified securities shall continue for the remaining period with the transferee, and such transferee shall not be eligible to transfer them till the lock-in period is stipulated. So the transfer is allowed 1 year only. I mean one time only one time. So if you are a holder of the security, you are not a promoter, okay, and your lock-in is 6 months, you can't transfer. Okay, these are like pre-IPO people, but you want to take an exit. So there's a lock-in period of 6 months. You can transfer to another existing shareholder who are also invested in pre-IPO. Now you have sold the shares to me. I want to again sell it to somebody. Not allowed. Transfer is allowed only once. Transfer is allowed only once. Okay. Let's quickly recap. So promoters lock-in is 18 months. However, it for capital expenditure, then it is 3 years. Okay. Then whatever is above 20%, if you want to transfer promoter, you can transfer there. The lock-in is basically 6 months, and if it is for capital expenditure, then it is 1 year. Okay. Normal people, your lock-in is for basically 6 months. 6 months. Then employees under ESOP ka trust, it is not applicable. Okay. And shares held by venture capital fund, alternative investment fund, their lock-in is basically 6 months. Then green shoe option may, if some we have given the securities to some agent, there the lock-in period is not applicable. Partly paid up shares where the called up money, the amount called up on specific security is less than the amount called up on the specific securities issued to public, the lock-in will be for 3 years. You have to mention non-transferable, and you can take a loan on those securities except superior right equity shares. Okay. Promoters, your lock-in is 18 months, 36 months for capex, 6 months and 1 year for capex. Okay, about 20% wala. If you want to sell, you can sell it, you can transfer it to another promoter or a promoter group or a person of a promoter group. Okay, normal people, if you want to transfer, you can your lock-in is 6 months basically, you can transfer it to another holder of the securities, but that transferee cannot retransfer again to any other person, not to you also, because the transfer is allowed only once. Cool. Read lock-in wala points. Read. Done? No. Cancel disclosure, not so important. Pricing. It says the issuer may mention a price band in the offer document. Price band is like 20 to 30 rupees. That's the price band. So you give a lower price, you give a upper price. We call it floor price and the ceiling price. The low price is called as the floor price and the above price is called the ceiling price, the top price. Okay. The issuer may mention a price or a price band in the offer document in case of fixed price and a floor price or a price band in the red herring prospectus in case of book building issue, and determine a price later before filing the prospectus with ROC. Then the cap on the price band at the coupon rate in case of convertible debt instrument shall be less than or equal to 120% of the floor price. Shall be less than or equal to 120% of the floor price. So it's 120% of the bottom price. That's floor price. The cap of the price band shall be at least 105% of the floor price. 1 second. The cap of the price band and the coupon rate in case of convertible debt instrument, it is 120% of the floor price. The cap of the price band generally it is 105% of the floor price. The floor price or the final price shall not be less than the value of the specified securities. It has to cover at least your face value. Whether issuer opt not to make disclosure of the floor price or the price band in the RHP, he should disclose the same at least 2 days before the opening of the offer. So in RHP we do not write about the price, we inform it before 2 days price. This we must have done at intermediate level. Then cancel point number 5 and 6. The issuer may offer a specified securities at different price. Like for employees we give discount. Employees quote is given discount. So retail individual investors or employees, shareholders or employees entitled for reservation may be offered a specified security at a price not lower than by more than 10% of the price at which the net offer is made to the other categories. So that's maximum discount can be 10%. So employee quota, we say employee quota, I'll just show you. Employee quota is basically 10%. In case of book build issue, or the specified securities offered to anchor investors shall not be lower than the price offered to other applicants. Okay. In case of issuer opts for alternative method of book building, then the issuer may offer the securities to its employer at a price not lower than by more than 10% of the floor price. So maximum it is 10% discount. Maximum it is 10% discount. I'll just show you. Like for example, I'll type Swiggy IPO. Let's type Swiggy IPO. Okay. If you see Ether Energy का IPO. Okay. So Ether Energy IPO price band is set at 321 rupees per share. So they have given a price band at 321 per share. Okay. The issue includes a reservation up to 1 lakh shares for employee offered at a discount of 30 rupees to the issue price. Issue price is 321. So they have given maximum discount as 10%. So they have given 30 rupees ka discount. Understood? So you can give a differential price. Basically discount you can offer is maximum 10%. Okay. Then, subject to the compliance of the provision of the Companies Act, a public issue may be opened within 12 months, from the date of the issue of observation by the board. So once SEBI is approved, you can issue within 12 months, and an issue shall be opened after at least 3 working days from the date of filing the RHP in case of book build issue, and the prospectus in case of a fixed price issue with ROC. So in case of prospectus and RHP, it is basically 3 days prior, to the date of filing. Cool. Read this much. Read pricing wala point, differential pricing and issue conditions and procedures. Read. Done? Cool. So we stop here, then we continue from minimum subscription in the next class. Okay, cool guys. Bye bye, take care, enjoy, and aim for a rank or 70 plus, which is earlier. We continue from minimum subscription. I think more 3 to 4 classes will take because your majority content will get over in minimum subscription only. Other part would be just cancelled. Okay, because there is no question. See, this they have given like full guidelines they have given, but in the exam I say will not ask us full guidelines, na? Okay, cool. We continue in the next class. Bye guys, take care. Hi guys, welcome back to the class, and we were doing our SEBI. SEBI, we have completed SEBI Act, we have completed LODR, we have completed ICDR. Now we are moving on to minimum subscriptions. Minimum subscription. Okay, let's start. Sir, what are your minimum subscription? So it says the minimum subscription to be received in the issue shall be 90%. So whenever a company comes up with IPO, so how much percent should be subscribed? So 90% of the offer through the offer document, except in case of an offer for sale of specified security. So how much percent? So 90% of the offer should be specified. 90% of this offer should be subscribed. Okay. Provided the minimum subscription to be received shall be subject to the allotment of minimum number of specified securities as specified in SECRA. So you just remember 90%. 90% of the offer should be subscribed. In the case of event of a non-receipt of minimum subscription, 90% not achieved, all the application money shall be refunded within 4 days from the closure of the issue, but not later than 4 days. So you remember the 4 days. You need to refund it within 4 days. You need to refund it within 4 days. IPO shall be kept open for 3 working days and not more than 10 working days. So 3 to 10. People should subscribe for the IPO between 3 to 10. So if you are opening the offer today, like for example, Swiggy came up with IPO. So Swiggy has opened it today. So Swiggy can't close it today only. Swiggy can't close it today only. Correct? They need to open, they need to close it, they need to keep it open for at least 3 working days so the people will subscribe. So minimum is 3, maximum is 10. So write the 3 to 10. The issuer shall extend the bidding issue period disclosed in the RHP for a minimum of 3 working days subject to the provisions of sub-regulation 1. Like in case of you are revising the price band, then again after revision 3 working days it should be open so people can apply. In case of force majeure, banking strike or some similar circumstances like COVID came or maybe flood or like India-Pakistan war was about to happen, the issuer may, for reasons to be recorded in writing, may extend the issue period disclosed in the RHP or the issue period disclosed in the prospectus for a minimum 3 working days subject to the provision sub-regulation 1. So you can extend it for 3 working days depending upon the situation. So generally it is 3 to 10. 3 to 10. Minimum subscription is 90%. Then the issuer shall stipulate in the offer document, that is prospectus basically, the minimum which shall fall within the range of minimum application value of 10,000 rupees to 15,000 rupees. So a subscriber, a public can apply for the IPO for between minimum 10,000 to 15,000 rupees. Minimum 10,000 to 15,000 rupees, and therefore in the multiples of. So the issuer shall invite applications in the multiples of the minimum application value, that's 10,000 to 15,000. 10,000 to 15,000, 10,000 to 15,000. Please underline that. The minimum sum payable on the application shall be at least 25% of the issue price. So application money should be 25%. Application money as per SEBI Act is 25%. So please mark all these are your small MCQs. Minimum subscription 90%, it should be achieved. Then if it is not achieved, all money should be refunded within 4 days. Then offer should be open for 3 to 10 days. It can be extended for some force majeure, some natural calamities happen for minimum 3 days. Then the application should be, the size should be between 10,000 rupees to 15,000 rupees, and therefore in the multiples of. Then manner of calls. So in case the issuer proposes to receive subscription manner in calls like first call, second call, then the applicant, if the applicant fails, the outstanding subscription money is called within 12 months from the date of the allotment of the issue. So entire money should be achieved within 12 months. All the calls should be made within 12 months. All the calls should be made within 12 months from the date of the issue. Now, if any applicant fails to pay the call money within the said 12 months, the equity shares shall be forfeited. It shall be forfeited. Then, write the regulation for an RTP. Come to regulation 50. Just remember the interest point. Where the specified securities are not allotted or application money is not refunded. If minimum subscription is achieved, you will allot the securities. If it is not achieved, then you will refund the money. It should be done within 4 days. The issuer shall and if it is not refunded within those days, the issuer shall pay 15% per annum interest to the investor. Circle 15% interest. Please circle 15% interest. Then 51, 53, 54 cancel this. Further issue of capital cancel. 57 cancel. 58 cancel. Read minimum subscription application, minimum application value. Regulation 45, 46, 47, 48. And read 49 also. Plus 50. I think 50 also we have done interest. Read. Read regulation 45 to 50. Okay. Done. Now come to FPO. I hope you are clear with minimum subscription. Minimum subscription is basically 90%. Okay, remember this. You must have done it at inter level also. Now come to FPO ka part. Highlight FPO. So we have completed IPO. Now we are doing FPO. FPO is basically subsequent issue. So here you will not say issuer. Here you will say what? Listed company. An issuer making a further public offer of specified security shall satisfy the following conditions. Okay. So all answer is almost same here. They have to comply with the draft document with the board and also the offer document with the ROC. Okay, so they have to comply with this chapter and as on the date of filing of the offer document with the SEBI and offer document with the ROC. Check out point number 2. Was it same? There should be no promoter or promoter group who have been debarred from accessing the capital market, or they have debarred from the capital market by the board or by the SEBI. Any of the promoter or director is a promoter of any other company which is debarred. If the issuer or any promoters is a willful defaulter or fraudulent borrower, okay, or is a fugitive economic offender. Vijay Mallya, Nirav Modi ka example I have given. It's exactly same as IPO. Eligibility. An issuer shall be eligible to make a FPO if it has not changed. It has not changed in the name in its name in the last 1 year. Immediately present the date of filing of the relevant offer document. If they have changed the name in last 1 year, immediately present the date of filing. Then at least 50% of the revenue for the preceding 1 year should be earned by it in the new name. Same answer. Issuer fails to satisfy the stipulated condition. 75% is offered to QIB to refund if it fails to make the minimum set allotment. Same answer. General conditions, same. They have made an application to stock exchange. They have entered into agreement with a depository, and all the existing party paid up share either have been fully paid or have been forfeited, and it has made arrangements for arranging the finance. The general corporate purpose should not exceed 25%. So write as same as IPO. Same as IPO. Additional conditions. Same as IPO. That it should be a period of at least 1 year from period prior to the filing of draft offer document. That 1 year wala condition is not applicable in case of OFS by the government company or any statutory authority, or equity shares were offered of sale were acquired pursuant to any scheme approved by High Court or a tribunal or by CG, or were issued after under a bonus issue, or were offered by a bonus issue. It is same as IPO, right? The same as IPO. So in FPO, no new conditions. It is same as IPO. No new conditions. Okay. Then FPO का convertible debt, instruments and warrants. Just write the same as IPO. See, moreover, it's an MCQ based paper. It is difficult to remember everything. Whatever is same exactly, so we're writing as same as IPO. So you use your knowledge. You use your knowledge of IPO and write here same as IPO. Anyways, it's very difficult to remember all the conditions. So you use your knowledge of IPO only. We'll solve the questions from the module. So we'll have an idea exactly what is the level of question they're asking from the regulations. More importantly, SEBI Act and LODR. So till lock-in also same, 18 months if you remember. So you can see it is 18 months. If it is capital, it is 3 years. Whatever is more than 20%, it is 6 months and then 1 year. SR equity shares will be same as ordinary shares. It is same. Partly paid up shares, 18 months. You have to write non-transferability. You can pledge it out. Same answer of IPO. You can sell it to whom? Any another promoter or any promoter group or a new promoter who is in control of issue. Same answer of IPO. Disclosures cut. There also we have cancelled. Cancel this, cancel this, cancel this. Pricing. Write their RTP. How much discount we can give to employees? 10%. How much discount? 10%. How much discount we can give? 10%. Issue conditions and procedures. Come to this. Now, regulation 103. 1 second. Huh? How much you can offer? If an issue is made through book building process under sub regulation 1 of regulation 103, then minimum 35% to the retail individual investors, minimum 15% to non-institutional investors, that is basically 50% covered, and not more than 50% to qualified institutional buyer, 5% of which shall be allocated to mutual fund. So it is 35, 15, 45 and 5. 45 and 5. So this is basically minimum, this is basically minimum, this is basically maximum. Now, if you remember that if you have contravened that 1 year wala condition is not applicable, and if you are going for book building, then your 75% should be to QIB. I'll just show you once. It is written in regulation number 103 here. An issuer shall be eligible to make a FPO if it has not changed its name in last 1 year prior to the immediately preceding the date of filing the relevant offer document. If it has changed in the 1 year, the 50% of the revenue should come with the new name, correct? Now, where issuer fails to satisfy the above condition, in such a case the issuer shall make FPO only if the issue is made through book building. Issuer has taken at least 75% of the net offer to QIBs and to refund full money if it is fails to make the said minimum allotment. If 75% is not allotted, he will refund the money. He will refund the money. Okay. So that is regulation number 2. 103 ka condition number 2. So if you are going with that, so 75% would be offered to QIBs. So what is the breakup? Sir, 75 to QIB, 5% of which will be given to mutual fund. So 70 and 5. 1 second. Not more than 10% to retail investor, not more than 15%. So 25 is left. So this is both maximum. Not more than 10 to retail, not more than to non-institutional investors, and 75 to qualified institutional buyers and 5% to mutual funds. I mean 70 and 5 basically. The breakup is 70 and 5 there. Then 3A. If an issue is made through book building process, the non-institutional investor category shall be as follows. 1/3 of the portion available to non-institutional shall be reserved for applicant with application size of more than 2 lakhs and up to 10 lakhs. So we call them as high net worth individual, HNI, high net worth individual 2 lakh to 10 lakh rupees. 2/3 of the portion available to non-institutional shall be reserved for applicants of more than 10 lakhs. So small HNI, big HNI. So small HNI is 2 to 10 lakhs, big HNI is more than 10 lakhs. I'll just show you. Now if you see retail minimum maximum, we have given the figure of 10 to 15,000, the maximum figure is 15,000. So retail one lot you will apply of maximum 15,000 rupees and therefore in the multiple. So if you multiply, shares is 46 shares, 14766 is the amount. If you multiply 13 lot, so 13 to 46 will give you 598. If you multiply the price, you will get 1,91,958, that is retail. Okay. SHNM means small high net worth individual. So we just studied 2 to 10 lakh rupees, 2 to 10 lakhs. If you see maximum of SHNI is basically small HNI, 9,89,000. Big HNI above 10 lakh rupees, above 10 lakh rupees. So this can vary company to company. This is of Ether. In the previous slide I was showing you Ether. This is Ether IPO. You open any IPO, you will get this. So retail is maximum 15,000 one lot. Then in the multiples of up to 2 lakh rupees. If you want to invest more than 2 lakh rupees, you will become what? Small HNI up to 10 lakh rupees. If you want to invest more than 10 lakh, you will become big HNI. So the breakup here is of that. So 1/3 is for small HNI, 2/3 is for big HNI. 1/3 of the category. So 1/3 of the category is this one, non-institutional investors. So not less than 15. The minimum 15% is for this category. In that also there's a breakup. 1/3 and 2/3. 1/3 is for the small HNI, 2/3 is for the big HNI. Provided unsubscribed portion in either of the subcategories may be allocated to applicants in other subcategories of non-institutional investors, if any is pending. Okay. If an issue is made other than through book building process, allocation of net offer shall be minimum 50% to retail individuals and remaining to individual applicants other than retail individual investors and other investors including corporates, body corporates, institutions, irrespective of the number of specified securities. So whatever we studied is for book building process. If it is other than book building process, like directly you are applying, generally 99% today climate is book building process. That is basically demand and supply. People will build, that is book building, people will build it. Okay. The issuer make reservation comparative basis of the issue excluding promoters contribution in respect of employees and shareholders other than promoters group of listed subsidiaries or listed promoter company. So you can keep a reserve category for employees and for other promoter group companies, like basically subsidiaries. Then please mark this, limit on reservation for employees. The aggregate of reservation of employees shall not exceed 5% of the post issue capital and the value of allotment to any employee should not exceed 2 lakh rupees. Then in the event of under subscription in the employee reservation portion, the unsubscribed portion may be allotted on a proportional basis for a value in excess of 2 lakhs subject to maximum 5 lakhs. So employee ke liye maximum it has to be 5% of the issue capital, that is in terms of number of shares. The value would be 2 lakh rupees. However, if it is under subscription in employee category, you can allot more shares but the maximum value should be 5 lakh rupees. Limit on reservation for shareholders shall not exceed 10% of the issue size. So the existing shareholders, it is maximum 10% of the issue size when no further application can be made. No further application for subscription, the net offer can be made by persons in favor of whom the reservation on competitive basis is made. So you can cancel this. Cool. Cancel this 131, 133, 134. No concept. Security deposit. The issuer shall before opening of the subscription list deposit with the stock exchange an amount calculate the rate of 1% of the issue size. 1% of the issue size. Circle 1% of the issue size. Cool. So till here you have to read. So study the breakup ka part. It is important. It can come in MCQ, and deposit is basically 1% of the issue size. I hope you have cancelled the other part. Just read this much. Page number 256. Issue conditions and procedures. Come till underwriting. Read. Done. Now come to underwriting. So we just need to remember the percentage of underwriting. I'll explain you underwriting ka concept once. Now I am coming up with an IPO. I am very much sure that I will get a subscription. Okay, but there is a risk. If 90% we just did, 90% is not achieved, then I have to need to refund the money, and then there will be a cost to it. So I hire some people. Okay, they give me a guarantee that, sir, if public is not subscribing, whatever is the balance, we will subscribe. So they take a guarantee. So those people are called as underwriters. Imagine it is over subscription. So those underwriters will not take any shares, but still we will have to give them commission because they have given a guarantee of not shares subscribed, on the shares guaranteed. On the shares guaranteed, okay. So it says, if the issuer makes of FPO other than through big building process, decide to have underwritten, it shall appoint merchant bankers or stock brokers registered with the SEBI to act as underwriters. So not normal people, only the people who are registered with SEBI can become the underwriters. If the issuer makes a public issue through book building process, the issue shall be undertaken by the lead manager and the syndicate members. Provide at least 75% of the net offer proposed to be compulsory allotted to QIBs for the purpose of compliance. That's 103 ka sub regulation 2. That 75% should be given to QIBs. The issuer shall, prior to filing of the prospectus, shall enter into agreement with the lead manager and syndicate member, indicate the number of specified securities with they will subscribe to act at a predetermined price in case of under subscription. If the syndicate member fails to underwrite the obligation, the lead manager will fulfill the underwriting obligation. The lead manager and syndicate member shall not subscribe to issue in any manner except for fulfilling their underwriting obligation. So because they would know everything about the company, so they can't just go and subscribe to the shares. They have to route it only for the underwriting process. In case of every underwritten issue, the lead manager shall take minimum underwriting obligation as per SEBI regulations. Whether issue is required to be underwritten, the underwriting obligation should be at least extent of minimum subscriptions. That is 90%. Monitoring agency cancel. Issue related advertisement cancel. The minimum subscription should be 90%. Circle that. The money should be refunded within 4 days. Same point. So majority content is same. Then FPO shall be open for 3 working days, not more than 10 working days. 3 to 10. You can exchange for 3 working days in case of any force majeure, natural calamity. Same concept. Issue size would be 10,000 to 15,000. Underline that. Point number 2. Application money shall be 25% of the issue price. Same. Should be made within 12 months. Applicant, if fail to pay within 12 months, they will refund the money. They will. So not refund, the share would be forfeited. The shares would be forfeited. Same answer. Allotment cancel. Refund is 15%. Circle 15%. So we are quickly marking whatever is the important content. So much you don't have to study. So IPO, FPO content is almost same. Okay. Post issue advertisement cancel. Lead manager cancel. This cancel. Miscellaneous cancel. Regulation 153, write there RTP. Then acquisition of shares and takeover regulation 2011. Cancel. Definitions. Cancel. See, voting rights and all, they will ask from the Companies Act, not from the SEBI. SEBI, they will ask about LODR and everything. Okay. Cancel this. Waste. Kassa. Kuppai. Come to insider trading. Hmm. Now come to insider trading directly. Rest everything is cancelled. In insider trading, you need to understand the meaning of what is insider trading, okay, and who all are guilty here, and when you will not be guilty, and when you will be guilty. Now it says insider trading denotes the dealing in company security on the basis of confidential information relating to company which is not published or not known to the public, known as unpublished price sensitive information, UPSI. Oopsie, oopsie. Unpublished price sensitive information, unpublished price sensitive information, unpublished price sensitive information, which is used to make personal profits or avoid loss, which is used to make personal profit or avoid loss. Okay. Now, if we are about to acquire a company, okay, imagine I am a director of a company and my company is about to acquire one company. It's an important information. The time it goes to public, because it's a very good news, the price will rise. Okay, so one of my employee shares this information with his friends that my company is going to acquire a company, you please buy the shares of the company. So it is unpublished price sensitive information. Oopsie. Now he will gain, the employee will gain, employee friends will gain. So all those people are guilty of insider trading. All those people are guilty of insider trading. Insider basically means a connected person or is in possession of having access to UPSC. Oopsie. Whereas connected person basically means who is, or during the 6 months prior to the act, been associated with the company, like an auditor or a consultant, you were there with the company in the past 6 months in any capacity, including by reason of frequent communication with the officers, or being in contractual fiduciary or employment, or you hold a professional or business relationship with them, or whether temporary or permanent, whatever relation, there is a relation of the company in the 6 months prior to the happening of the event. Then the person falling within the above category shall also be deemed to be connected person if you are a relative, immediate relative of connected person, a holding subsidiary associate company, or an intermediary, or an employee or director, or an investment company, trustee company, AMC, or a employee director thereof, an official of a stock exchange or clearing house, a member of the board of mutual fund, then board of directors of or an employee of PFI, or like bankers also know more information. Okay, the banker of a company, a trust, HUF, company, association, or person. So these people are called as connected persons. These are called deemed connected person basically. It may be noted that the above definition intends to bring into the ambit person who may not seemingly occupy any position in the company but are in regular touch with the company. So even though like a banker do not have a position in the company, but he's connected with the company somehow, right? He deals with the company maybe for funding, maybe for loan recovery, whatever it is. Okay. Now, generally available information is defined as information that is accessible to public on a non-discriminative basis. It is intended that anyone in possession or having access to UPSC should be considered insider regardless of how one came in possession of or had access to such information. Okay. Any information published on the website of stock exchange would ordinarily be considered generally available, like these things: financial results, dividend, change in the capital structure. This will be readily available. Cancel this. Cancel this. Now, communication of. So you understood the definition basically who are connected persons. So if you are dealing any information which is price sensitive, which is not published, which is not readily available to public, okay, and you are sharing this, so you are called as a connected person and you are guilty of insider trading. So any UPSI, oopsie, unpublished price sensitive information, if you disclose it to the public for your personal gain or for the gain of your connected persons, you will be guilty of insider trading. Okay. So these are more rules they have given in detail. So if you want to read, you can read this right there. RTP, I have given you an explanation what exactly is insider trading. Okay. Come to page 288. In case of connected person, the onus of establishing that they were not in the possession of UPSC shall be on such connected person. In other cases, it would be on the board. In case of connected person, you need to prove that you are not in possession. In case of others, it will be on SEBI that they were not in possession. Okay, remember this. Cancel this trading plans and everything. Cancel. Cancel. Oh, last penalty. Penalty for insider trading. This we have already studied. Okay, 10 lakh rupees to 25 crore rupees or 3 times the profit, whichever is higher. Whichever is higher. Penalty for insider trading. If any insider who either on his behalf or behalf of any other person deals in the securities of a body corporate listed on stock exchange on the basis of UPSI or communicate any UPSI to any person with or without his request for such information except which is required in ordinary course of business, like for example board meeting ka date is ordinary course of business, if you are sharing that you are not guilty. Okay, or conceals or procures any other person to deal in any securities of any body corporate of UPSC shall be liable to a penalty of 10 lakh rupees subject to 25 crore rupees maximum or 3 times the profit mean whichever is higher. So 10 lakhs to 25 crores or 3 times the profit, whichever is higher, whichever is higher. So penalty you need to remember and the definition of insider trade and the connected person. Okay. So giving you 5 minutes, just read the penalty again and the connected person ki definition so that you are clear what it is. Rest everything is read, not to be studied for the exam. Okay, not to be studied. Read the definitions and the last penalty. Then we'll solve the MCQs. Read. Done? Cool. So now we do the question from the module. Let's do module. Now see, these are module questions. Let's start. Wow. Number one. 1 second. A video is little blur, I think. Hmm. Let's do the question. Ayush Bipin Caravan Company form of C was appointed as the start auditors of Ruchika Flavors Limited listed company for the financial 1920. Mr. Bipin is an engagement partner of the said firm with a team of 15 members. While conducting the audit of the FS of some company, other company, 2 members of Bipin team was CAs passed the information to their friends and relatives disclosing the profits of Ruchika for the year are increasing by 25%. So disclose this information, confidential information. We just did insider trading. Oopsie. Unpublished price sensitive information. In comparison to the previous audited financial, that passing of information it was not available in the public domain. So it's oopsie. Who certain persons who were in possession of the information purchased the shares of company at a low price. After the audited FS came into public domain, the market price increased sharply and they made a profit by selling the shares earlier purchased at low price at enhanced market. You are required to select the correct option which indicates it is a case of insider trading or not. Yes, it is a case of insider trading and the quantum of penalty. Logic it is. We just did. Tell me the option. We just did. I told you it's important. Insider trading word is important, penalty is important, 10 lakhs to 25 crores or 3 times the profit made, whichever is higher. C, 1 ka C. 1 ka C. 2. Akshara Builders and Developers, a company listed on BSE, is contemplating upper revision the rate of interest of its existing 12% bonds by 1%, so make to the 13% bond with effect from 14th August. The said proposal will be held on board meeting to be held on 14 July 21. From the following, choose one, indicate the latest option by which Akshara Builders need to intimate BSE about the board meeting. Intimate the board meeting. Board meeting was different. Intimation of the board meetings. 10 days before. Intimation of board meeting. Excluding the date of meeting. Meeting is on 14th July now. One second. Hmm. 11 working days. Any alteration in the form or nature of securities to be held on the stock exchange or any alteration in the date on which the interest on debenture bonds or redemption shall be payable. 11 days. To 14, 11, 3, 10, 3, 3, 3, 3, 3 working days. 3rd July. 3rd July. B. W made following compliance for the June 22 quarter as required by SEBI. If submits its unaudited quarterly FS to the recognized stock exchange on 31st July 22 and quarterly compliance report on corporate governance on 10 July 20. Quarterly compliance report, I told you, it's a very, very important within 10 days, 21 days. Oh, what is the question? What is the last date for submission of quarterly financial results to the stock exchange for W Limited in case W is not able to submit on 31st July? And whether it can be submitted in unaudited? Yes, it can be submitted in unaudited. That is very clear. So either B would be there or well, it submits its unaudited quarterly financial result to the stock exchange on 31st July. 31st July. Quarterly financial results. Within 60 days of the financial year, April, May, June. No, this is yearly compliances. Quarterly financial results. Within 21 days from the end of the each quarter. Oh, within 15 working days. Okay. 21 days is grievance release. This is 15 working days. So 31st July को they have given to 15th August. 15th August. 15th August. 15th August. 15th August. Fourth. Amar is holding a post of directorship in following listed company L1, 2, 3, 4, 5, 6, 7 on he received an offer of directorship from L8 in April 20. Whether Amar can join L8. Director he is. You can be a director in maximum 7 listed companies. You can be a director in maximum 7 listed companies. C. 4 is C. Four is C. Fifth. So no acquirer shall acquire shares of voting rights in target company which taken together with shares of voting rights if held by him and person acting with him in such target company entitle them to access -% of the voting rights in such target company unless the acquirer makes a public announcement. So whenever you are acquiring a shares of minimum 25%, you need to make a public announcement. So here it is 25%. So it's a direct question. We have cancelled all those regulations, but yeah, it's only this question you need to remember 25%. C. C, C, B, B, D, D, C, 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 C. Finish. Over. Completed. So whatever questions are there, we have done, guys. We have completed full SEBI, and with this, we have completed full your content of the syllabus. Okay. I hope you have understood. I have given you one MCQ book. MCQ covers chapter-wise MCQs, then it covers big MCQs, then it covers more big MCQs, then it covers mixed MCQs also. Case-based MCQs and mixed MCQs. Okay. And I'll be available on Telegram, Instagram. You can contact me in case of any doubt you have. The number of office is 844-844-8919. You can contact us and tell to them that I need to speak to sir, or you can WhatsApp them 9987 045 565 045 565. You can visit our website www.letslearnindia.in. Okay, we teach FR, AFM, audit and finals at all three at in-house. I am taking audit at CA Final. If any of your friend is an intermediate or cousin, relative, brother, sister, you can tell them I take integral law, inter-audit also. If you have studied inter through me, you know that. I hope I get to see you in class of regular audit. Okay, SPM is just a part. After SPM A, I'll just show you. One second. Yeah. So the website is open. Okay. So whatever content you want to download, any notes of any subject, you can go and visit the free resources here. Okay. You can go and click here. The time you click free resources, so you'll get SRE. This is for CA final audit. You'll have SRS ka free notes. Some tax or class is not for you. Then you will see niche, below FR top 20 questions. New compilations for CA final audit. CA final amendments, audit handwritten notes, audit past year questions. Okay. You will see Ind AS 110 consolidation revisions, LDR consolidation, super 30 questions of CA final audit. Okay. Plus you can go to course, go to CA final. So we have FR, we have AFM, we have audit final. The combo is there. SPM set is there. Okay. Now when we go to SPM set, you have set A, set B, set C, set D. Set B would be taught by Rito Bansal. You can buy either Hindi English or English version, whatever is your comfort. And I'll be taking a set C and set D in English. So in set C, I'll be teaching you forensics. This is 100% English, set C forensics, and set D would be entrepreneurship. So first I'll be starting with set C, that's forensics, and then later on we'll move on to set D, entrepreneurship and startup ecosystem. Okay. I hope I get to see in the next class. Do recommend to your friends and aim for a rank or 70 plus, which is earlier. And in case you are buying the regular course of audit, go to CA final, go to audit. Now the time you go to audit regular batch, so you'll see Hindi English batch and 100% English batch. So 100% English batch is this one. September 25, January 26, May 26, and so on. Okay, cool. Bye guys, take care, enjoy. Aim for a rank or 70 plus, which is earlier, and do clear your SPM and all the best. I hope you become chartered accountant as soon as possible. This was the last class of SPM. Bye guys, take care.